And 15 will come, by that time you will be there. Yeah. Okay.
49.
49 we also.
No.
Yes.
Your Lordship. This is a matter, Your Lordship. The tax deductor has been paid later on.
You are supposed to get the instruction.
So, Your Lordship has directed to the council appearing for the opposite party.
Where is he?
Did not come, Your Lordship. My Lord, may
Let
kindly
it come at its turn. See.
at 2 o'clock, Your Lordship.
It pass it over. Will come.
My Lord.
Yes. No, I have started taking up the matter. Take the give the memo. We'll see. No mention. I have started collection. Yes.
Item 1.
Please, my
Yes.
lord. Last occasion, my lord.
Hmm.
Directed to file the Congress order.
हमारा कौन स्टेट बटन
Yes.
अरे जो 1 पेपर है
My lord,
What is the case?
on the basis of complaint filed by the OPR 2 against
Now
the
you were asked to file the copy of complaint petition and other and order of cognizance. Where is complaint petition?
complaint petition was a cognizance order.
Just see the order.
Sorry.
See, the order is the Land Counsel for the petitioner is directed to file the copy of the complaint petition and the order of cognizance for the perusal of this court. First of all, you file something without any document. Even if the court passes the order, then also you don't file.
देखवा
File कर
तो जो कोड दवा था करना
ऑनलाइन फाइल कर दीजिए
कोड राशन
नहीं, कुछ नहीं तो-
कोड राशन मतलब कोड रहा था करना अरे कोड रहा था करे
You withdraw it and file a fresh one.
tomorrow, my lord.
Not tomorrow. There are a lot of memos are coming.
Next
Can't
week,
keep
next
on
week,
keeping-
next
No,
week,
no,
edited.
then it will go to March, end March. You think over it.
Next
March. Court can't give indulgence like this very frequently because the people are in queue. Just everybody is mentioning. You got an opportunity, second opportunity, third opportunity, you don't file it. How can the court give
I will
indulgence?
not follow the order, my lord.
Adjourn it to the item 2 now. Please cooperate with the court.
But next week, edited.
No, next week. It's not possible at all.
One week after, my lord. 1 week after. 1 week
We
after.
will see whenever the date is possible, we will give. Because you got two indulgence.
Well,
Court
sorry.
passes an order to file something, you don't file. First petition without any annexure. When court says that file to annexure, then also you don't file. You are wasting the court's time, at the cost of other people, those who are in the queue. Next item 2.
Item 2.
My lord, 1 week after.
We will see what. Yes, 2.
Item 2, my lord, the instruction was called for whether that injuries are simple or
Yes.
that advocate matter like that on the
Yes.
election
What is that?
injuries.
there is absolutely no injury
No injury.
No injury.
20 चिपी देले चापड़ा मारले allegation से तो लिखते ले फेर जे मो मेडिकल ट्रीटमेंट हेले चार्जशीट हेछि नो इंजुरी
That's right.
चार्जशीट 307 कटि जाइछि 323 अछि
323 so
माला
very charge sheet. Because the petitioner is seeking petitioners or petitioner. One.
Petitioners.
not 294 323 34 चार्जशीट
Okay.
आसिना
The petitioner is seeking quashing of the criminal prosecution against him, initiated persons to the FIR number, page, whatever page, just see page 8, FIR particular under section so and so. Next paragraph. After the investigation, the charge sheet has now been filed under section
294 323 34 पाइबिसी
34, right? Full stop. Although there was allegation of bodily injury of the victim, but after investigation it was found that the injuries are simple in nature. Therefore, section 307 IPC has been dropped.
Injury किछि नहीं.
से देखा
Has been dropped. Okay. Although has been dropped. The land counsel for shown to appease, but land counsel for petitioner and shown to appease for party number shown. The matter was taken up on 9/1/2024 This court passed the following order, para 3. Para 3. The following order pura de do. Following order pura de do. Following order. Full sir. Pursuant to the aforementioned order, the Mr. Rogada has sought instruction and submits that there is no legal impediment for quashing of the FIR, quashing of the FIR, quashing of the FIR and subsequent proceeding. How much cost will go? You are a lawyer, you are not supposed to fight in the bar. How much cost will you pay something? The lawyers are not there to fight in the bar.
नहीं
Bar election, you are maybe you know you may not be a serious
इलेक्शन डेट रे से प्रचार को नहीं की
क्या भी
हाँ, जा।
आप तो झगड़ा कर ना
ଦିଅନ୍ତୁ ପଇସା ଦିଅନ୍ତୁ ବାର ଦେବେ ନା।
फेर देवे
ଆମଟି ବାର को ଆମେ ଦବ
जार बार दियंतु आपण बार दियंतु
ହଁ ସେ କେନ୍ଦ୍ରାପଡ଼ା ବାର ଦିଅନ୍ତୁ।
आपण बार दियंतु
କରିବ ବାର
ଆମ ସବୁଠି ହାଇକୋର୍ଟ ହଉଛି।
କେତେ 5000 ଦିୟंतु आपण बार
ଆଜ୍ଞା
ठीक ଅଛି
ଆଜ୍ଞା
taking into consideration the aforementioned facts and circumstances, I am of the view that this is a fit case where the jurisdiction under 482 CRPC could be invoked. Accordingly, the FIR number so and so and subsequent proceeding arising therefrom is quashed. Since the accused is an advocate and who has indulged in this case, which is not befitting for a lawyer. Therefore, he imposed the cost of ₹5,000 to be deposited, which are
केंद्रापड़ा बार एसोसिएशन
welfare fund of Kendrapara Bar Association, to which the accused belongs.
Okay. They are the member of that bar.
Member of it.
Okay.
To which Kendrapara Bar Association, to which in which the petitioner is also a member.
Right.
Okay.
Objection.
Item 3,
Not pressed, no instruction.
No instruction.
No instruction.
Please to withdraw.
Obligation.
item 4,
Yes.
My lord, petitioners are my lord, petitioners are face trial under offense 324, 324, 307, 506 along with 34 of IPC, my lord.
Yes.
At the Court of Law and Additional Sessions of Jananpur. And my lord, petitioner here challenged which is under Annexure 1, order dated 16 May 2023, my lord. My lord, petitioner prayer for call for the OPD register from SDH Anandpur. And that application rejected by the Law and Trial Court, my lord.
What is the reasoning?
My lord, kindly see case
This matter was already argued.
Argued. Your lordship, last occasion directed them to they can cite the test OPD register at the time of defense, their defense.
Yes, yes.
But that view had already taken. For that they have taken time.
Not the time.
My lord.
Fine. What is the reasoning?
Order is very clear, my lord.
Which paragraph you read out?
Page 7, my lord.
Page 7.
Here, page 7.
Verse 7
Burden
and burden lies with the defense to prove after my 1, 2, 3, 6 to prove, and the defense can produce the same before the court after obtaining copy as per rule. The prosecution has already filed the relevant medical documents on which they relied upon. At this juncture, this court of the opinion that there is no necessity to call for the OPD register from the ST.
The petitioner is challenging the order dated 16/5/2023 passed by additional district session judge Anandpur in ST case number 1 of 2018. whereby whereby his application under section 317 bracket 1 CRPC seeking direction to the prosecution to produce OPD register dated 22/4/2016 has been turned down. Full stop. The next paragraph. The petitioner is facing trial in a case under section.
Under section, my lord, 341, 324, 307, 506, 34.
Right?
Of IBC, my
Full
lord.
stop. He is finding his defense in the OPD register. Full stop. Copy of which has been relied upon by the prosecution. Full stop. The trial court rejected the application inter alia
My lord.
stating age under inter alia stating age under page 6 para it is noted from to last full stop. The OPD register next paragraph. The OPD register being a document in the public domain, the petitioner is always at liberty to obtain copy and rely upon for the purpose of his defense. Next, therefore, taking into consideration the aforementioned circumstances, the court is not inclined to exercise its jurisdiction under 482 CRPC. Hence, the petition is dismissed. Yes, next.
My lord, the concern IU sees that document also.
Whatever that is mentioned in the impugn order, I reproduce. This is the court that
IU sees that
and when the
document.
court is not with you, then you ask for adjournment. What is this?
My lord, I'm
You are a
sorry.
young guy. You should take on a
No, my lord, I'm not.
sportsman spirit. You argued well. I noted your argument. Why are you so this thing? And losing a case is not more important. You have done your job. That's more important.
My lord.
You justified your brief.
He wants
By
to,
arguing.
his senior will conduct the same thing.
He also tried.
Same thing.
He also tried.
He also tried twice.
The court was not with him, so therefore he took
He said
adjournment
he-
twice.
My lord,
And this is the third hearing.
my lord.
And he knows the result, therefore he has sent you. And you tried this. Thank you.
Item 6, item 5.
I permitted to withdraw.
Withdraw. Okay.
Item 6.
Pray for an adjournment due to personal difficulty, my lord. Pray for an adjournment.
Adjourn.
Item 7.
7, may I please, your lordship?
Yes.
I may be permitted to move on
Yes.
virtual mode.
Yes. Yes.
I have challenged the order passed by London District Judge, confirming the order passed by Executive Magistrate relating to 133 CRPC proceeding. My
Yes.
lord, I am a businessman, and while conducting inquiry, Executive Magistrate called for a report from RI. My lord, that is Annexure 1, page 8, my lord. Kindly see that.
Yes.
Annexure 1, page 8, my lord.
What is the allegation against you?
Allegation, my lord, I have parked the vehicle for loading and unloading of the goods of my shop. And regarding that, my lord, RI has given a report that is under Annexure 8, page 8, Annexure 1, page 8, my lord.
Where
Kindly
is the
peruse
copy
that.
of FIR?
No FIR, my lord. It is a complaint case before the Executive Magistrate. 133 proceeding.
Where is the complaint? Just see. Let us see.
Well, I have filed the order. Impugn order is page 15, my lord.
Now you want a quashing of what?
Quashing of order passed by Executive Magistrate,
what? What is that order?
that he has passed order that page 15, my lord. Kindly see page 15.
Yes.
Last para, my lord. It is therefore ordered that the opposite party members may shift their go down to any other open place, or else shift their timing of such activities, parking, loading, unloading, to off hours of the day, that is 8 p.m. to 8 morning. This is the order, my lord. But my use of that loading unloading, my lord, that is described in Annex 1. My lord. Only 2 to 3 hours per month, my lord.
Therefore, order that the opposite party members may go down to any other open place, or else shift their timing of such activity, parking, loading, and unloading of the so from 8 p.m. to so.
This is the complaint lodged by my business rival, my lord. He has a cloth store just in front of my my lord.
Then you challenge
And
this
there is no allegation of any corner.
1 minute, you challenge this order before the district.
My lord, opposite party approach executive magistrate.
What is the session just says?
He says, my lord, my vehicle obstruct the road and which affect the public activities, my lord. But there is no allegation from any corner except these opposite parties, my lord. Your lordship will be clear from Annex 1, my lord. This is only the report.
These are administrative exigencies, then what court can control?
Yes.
My lord, only 2 hours from once in a month, my lord.
Where is this place?
This place is in Kalahandi, Rupra Road.
Kalahandi?
Village area. Kalahandi, village, Rupra Road. Under Norla police station.
Yes, my lord. The session judge has rightly conclusion that the road is blocked by the petitioner. The court has specifically directed that either you shift your vehicle, your godown somewhere else as per your wish in a suitable place, or you change the timing. Because that time is so, my lord, rash and negligence. My lord, there was very
peak
weird.
hours, peak
Yes,
hours.
my lord.
Where the traffic.
That is why you'll also may kindly see the photographs. How the
Yes, I have filed the photograph, my lord. No vehicle is
blocking the roads.
Where is that photograph?
My lord, at page 37.
Page 17 onwards.
My friend is annexed.
Page 17 onwards.
37. The road.
And there is no blockage of road.
Only relying upon this RI report. Where is that RI report? What does it RI report say?
Yes, my lord. Annex 1, page 8.
Yes.
May I read, my lord?
Which part you are reading?
Entire inquiry report is for one page, my lord. I am reading, my lord. Last 5 lines.
Yes, read it.
My lord. Which the petitioner is hampering, but as for witness and sarpanch, this is relevant, my lord. As for witnesses and sarpanch, Sanjay Kumar Agrawal and Satish Kumar Agrawal only used to park their loaded truck for only 2 to 3 days in a month for 2 to 3 hours, and this is an usual activity of all the businessmen of Rupra Road.
Yes.
This is a law and order and this problem. Executive magistrate, what 482 for this? Right.
My lord, order of executive magistrate has been challenged before the district judge, Lorna district.
I understand. I'll note down. Look, right down. The petitioner had challenged the order dated 21/7/2023, passed by additional decisions judge Kalahandi Bhavani Patna in criminal revision number 34 of 2022. Order dated like that 21/7/2020. Whereby the order of the learned executive magistrate dated 2/12/2016 under section 133 CRPC has been upheld. Good, sir. Next paragraph. the so and so appears the Mr. Panda, land counsel for the N Panda, J N Panda.
J.N. Panda.
For the petitioner submits that the RI report indicates that both the petitioners are parking their trucks only for 2 to 3 days in a month, for 2 to 3 hours.
3 hours.
3 hours. And this is the usual practice, usual activity of the businessman in Rupra town road.
Rupra Road.
Rupra Road.
This is a village manner.
Rupra Road. Relying upon this finding of the RI, he is attacking the impugn order, the learned executive magistrate as well as the learned executive magistrates by taking into consideration the report of the
RI.
report of the RI. ये जो executive magistrate order थिला 4/10/2019 में
4/10/2019.
4/10/2019 अलगा ये क्या order executive magistrate order 4/10/2019 ठीक है 4/10/2019 the executive magistrate after taking into consideration the entire facts and circumstances and after much deliberation have come to the following conclusion. ये page 15 last para. It is therefore order that. See, the said order was assigned by the petitioner before the additional session judge Bhawanipatna, which has been upheld.
Sessions Judge Kalahandi.
Session Judge Kalahandi, which has been upheld. I am of the considered opinion that the arrangement made by the executive magistrate is apt in the facts and circumstances, apt in the facts and circumstances of the case, and no indulgence.
Kindly appreciate, my lord.
No indulgence of the court at this stage is called for. Therefore, the petition. Next.
Purely a private dispute, my lord. Just a business rivalry. Kindly appreciate, my lord. Or your lordship may issue notice, my lord.
No, I have disposed of. There is nothing. These are arrangements only. And at this, I have said that at this stage, if anything happens, you can again agitate it. Okay? At this stage, I have said.
Well, purely a private dispute. And 133, my lord, does not mean for.
Either you change the parking place according to your own wish, or change the timing. At least timing also will not adjust.
Well, but there is no hamper to the public activity, my lord. No allegation from any corner, my lord.
That's right,
except these two persons.
And see the executive magistrate's order, the lot of deliberation, lot of hearing taken place. After that,
the report was called for, my report was not.
Solution. He find a viable solution, and even that solution is challenged in the court.
And the
how the
also
will run?
Kindly appreciate 2 hours a day, once, twice in a month. And this is the normal. Even, my lord, this opposite parties also can't take it.
Next. Item 8.
Next. Yes.
Item 8, I pray for adjournment.
Adjourn.
Item 9.
You are asking adjournment, but remember, once you ask for adjournment, it will go in March. Because we have to accommodate other people, those who have given memos. You got a space, you should have utilized that space. Anyway. Next. Yes.
Item 9 is yes, I am appearing
Day after tomorrow, I can't.
next week.
Next week also. 1st February. We is trying to accommodate you in the 1st February.
I am finding an interim application.
Oh, it will come obviously.
Item 11.
Huh? You increase the number.
10th adjourn is. After
Increase the number, at least make it 60.
They made arrangements.
Huh?
I've made arrangements to increase that.
Huh?
I've made arrangements to increase that.
Increase, otherwise everybody is seeking adjournment.
No,
Then
no, I haven't done it.
wasting that. This is the whole difficulty. We accommodate on the basis of a memo, and people are seeking adjournment. As a result, by 2 to 3:30, 3 o'clock, I am free. I'm wasting 1 hour. Once it is listed, means you should argue. Otherwise, you are encroaching upon the, the other people's right to be heard. That's the problem. Increase. Huh?
I'll do it. I'll make the list.
Make the list and do it.
I filed this application.
Yes.
Passing of the entire proceeding on the ground of compromise, my lord.
What is the offense, sir?
Offense, my lord, tribal, all the.
Okay. Who are they?
No, let notice go, my lord, I have made party.
Okay.
Later after.
Informant, you have made the party.
Opposite party number.
Okay. The offense is not 323.
Yes, yes.
Tomorrow.
Yes.
Learned counsel for the petitioner submits that he seeks indulgence of this court for passing up the criminal prosecution against his clients under GR case number 90 of 2022, corresponding to Banapur PS case 101 of 2022. Under section, you write down from FIR. Okay, under section so and so. So, sir, he submits that the parties have settled their dispute and seeks the indulgence of this court for passing of the criminal prosecution. Issue notice to the opposite party number 2. Mr. Maharaj waives notice for and returnable within 1 week. 1 week.
Date may be fixed.
First week.
First
Is it? But you joint affidavit and everything. I need not see.
Yes.
You get and the party
Yes.
so that we can finish.
Parties will appear before your lordship.
That's better idea.
Yes, yes.
Yes.
Bring them so that we can. Yes.
Joint affidavit with the appearance.
Date may be fixed.
First February.
Oblate.
Item 12.
As per the lordship direction, both the parties.
Yeah, yes. What is the offense?
498.
498.
Material dispute.
Okay. You are the
Compromise is the.
you are the husband.
No, husband and wife both are taken.
No. Accused is only husband.
Only
Okay. What is the settlement terms? Huh? What is the settlement terms?
Government, they are deciding on one group.
Now they started.
Yes.
They are present also, my lord.
Board have-
They are present. Okay. The petitioner has filed this petition seeking indulgence of this court under section 482 CRPC and quashing of the criminal proceeding initiated against him by opposite party number 2. The opposite party number 2, opposite party number 2 pulls up. The opposite party number 2 is the wife of the petitioner who has registered this FIR under section P6. So and so. Pulls up. So and so. Now the parties have settled their dispute and started revived their marital life. Therefore, the opposite party number 2 doesn't want to press or and doesn't want to proceed with the criminal case against his husband. The parties have filed a joint affidavit before this court. So entirely are stating the aforementioned facts. The parties are present in the court. They are being identified by their respective counsel. They have also filed the Aadhaar photocopies of Aadhaar card before this court. Self-attested copies of their Aadhaar card before this court to establish the right of thing. Mr. Maharaj appealing for the state says that in view of the settlement, there is no impediment for passing the FIR. Next paragraph. Having taken into consideration the attending facts and circumstances, the FIR number show and consequential proceeding thereof are quashed.
Yes.
Quashed, and accordingly the petition is disposed.
Item 13.
Page 80, annex of 2 order is the NBW issued against the petitioner, my lord.
When was the bail?
That is on 3/11.
3/11?
3/11, 2022.
22.
Yes, my lord.
Okay. NBW order?
Annex of 2 at page 8, my lord.
8. Okay. Offense?
NBW issued the
Offense?
The offense 376, 109 and 32 SC/ST Act, my lord.
Okay.
But for the time petition could not be advanced. Could
No,
not be
no,
argued
this
by-
is accused, counsel accused files. No, when the bail was granted to you?
Bail granted, my lord, that was annexure 1 on dated 9/10/2017.
That's what I'm asking. 9?
9/10/2017. But court has taken an humble view of giving bail, my lord.
That's right, but you have been appearing
Yes, my lord.
all through.
Yes, ma'am. But on 3/11/2022, the Learned Council could not move his bail petition while the matter was called, my lord.
Bail petition, why
No,
bail?
time petition.
Time petition.
Time petition.
Time petition.
Okay. 1,000?
500.
More than that. 376.
500, my lord.
Give
My lord
1,000
is
because
passing usual order, my lord. for
don't
500.
disrespect your bar by paying 500. You are giving to your bar only.
Yes, ma'am.
High Court Bar Association.
Yes,
A good bar. actually.
yes, ma'am.
1,000. Dekho, same order. We take it. The petitioner is facing trial in so-and-so case. TR case number 166 of 112. Police has filed charge sheet under section annexure 2. Charge sheet under section so-and-so.
Yes.
And the husband of the deceased was put to trial.
Yes.
At the time of recording of evidence, the Sessions Court found evidence, prima facie evidence against the present petitioners. Therefore, by invoking section 319 CRPC, summoned these accused persons.
Yes.
Summoned these accused persons. The accused persons have challenged this said order in this petition.
Yeah.
The Learned Counsel for the petitioner submits that meanwhile, non-bailable warrants has been issued against the petitioner by order dated. By order dated. By the order dated 27/9/2020.
No, sir. 04/12/23.
4/12/2023. 4/12/2023. He seeks indulgence of this court at this stage.
Yes.
Next paragraph. Next, I am of the considered view that the order of summoning of the accused under section 319 CRPC needs no interference at this stage. However, the order of issuance of NBW is stayed till operation of the order dated 4/12/2023 issuing NBW against the petitioners are stayed to facilitate the petitioners to surrender before the
court below.
Surrender before the trial court.
Yes.
And seek their appropriate remedy. Seek their appropriate remedy. Give surrender for
2 weeks.
the operation accordingly, the operation of order dated 4/12/2023, passed by Learning Sessions as Bhadrak. It's stayed for 3 weeks.
For 3 weeks.
3 weeks from today. 3 week ଦେଇକି ଆପଣ 3 week ଭିତରେ apply କରନ୍ତୁ, bail ନେଇ ଯାଆନ୍ତୁ, NBW ତ stay ହେଇଗଲା. That is the best remedy. Bail ରେ ଆପଣ ସାଙ୍ଗେ bail ମିଳିଯିବ, because main accused is already on bail. And you 319 ରେ summon କଲେ bail ମିଳିଯାଏ.
Sir, main accused already arrest accused custody ରେ ଅଛି.
Maybe ଆପଣ ମିଳିଯିବ, because the charge sheet was not filed against you, isn't it? So it is only 319.
Husband only.
Oh, that's right. Only 319 is invoked. So you will get bail. What is the big deal? I have stayed the NBW. Go and get bail. 3 weeks time you have. Immediately you move. Yeah. Okay.
Item 17.
Before that.
Well, as far as this case is concerned, it was previously heard by Honorable Justice Sibo Sankar Mishra, and then after it has been listed before your lordship. As far as the status of the case is concerned, it was already, everything was over, and it was mentioned as part heard. If your lordship feels
Where
to
is
continue,
parted?
it is there in the order.
Argument in part, heard and parted.
Yeah, it is in the
But
order.
however,
our
this
part
kind
is-
of parted matter will go to same bench.
That is my lord, will go to same bench. But in fact, it is OPID matter, my lord.
He is there.
May I please your lordship, I am for the informant.
No, since see, order dated 28/8/2023.
Parted matter
says
go
parted.
go to that bench, my lord.
Go to same-
That is
Yes,
that matter. Go to that bench.
Once assignment change means the part had already released.
Exactly.
Automatically released, and that will
No,
go.
no, no,
Let
no,
that
my
go-
lord.
let
Since
that
the matter
court say that.
parted, that matter go to that bench, my lord.
Let
Unless
that court
until
say
that
that,
court
why should I
Say has it.
we presume things and
My lord,
parted is parted.
unless until that court release, my lord, the
1 minute,
matter.
I want to interfere. Before coming to this court, this was previously listed before Honorable Justice Chittaranjan Das.
Yes.
Okay, he told that I will go through the records as everything is complete. Pleadings are complete. We have filed all the written submission, and I will, if I need, I will take your help, or else I will pronounce the order. This was that. However, if your lordship wants to continue with that, we are prepared for that.
No, see, just Chittaranjan Das order doesn't indicate anything.
No, that is not, that simply not,
Whereas
nothing.
previous order, Justice
Yeah.
Srikanth Mishra's order, says its argument in part.
My lord.
Then
It's your prerogative, your lords.
propriety demands that it should go there. If he said passed by the coordinate bench of this court, coordinate bench, the matter is part heard before the said bench. Said bench. Therefore, I am of the view that the matter should be placed before Honorable Acting Chief Justice to assign the matter to the appropriate bench.
Yes.
Appropriate bench.
And registry may be directed to put registry directed.
Registry is directed to take appropriate step to release the matter before appropriate bench as directed by, as would be directed by the Honorable Acting Chief Justice.
Obliged.
Item 18.
18 wheeler kindly taken up next week, my lord. I have already contacted the informant, my lord. She will appear by next week, my lord.
It's a settlement, matter settled.
Matter has already settled. She has already get the full and final settlement money, my lord.
Offense?
Offense, my lord, 420/34 IPC.
Okay. First week, sir. First week. First week.
Item 19.
Item 20 kindly taken up next week, my lord.
Adjourn.
22.
March, huh? March end में जाएगा.
Item 19, my lord. Madam, 2 weeks time may be given.
Sorry?
Item 19.
Yes, 19 is passed over.
No, right.
Passed over.
But 2 weeks time may be given to appear before opposite party. Yes, yield, my lord.
Is the matter was settled?
Yes, yes. Settled.
Okay. What is the offense?
Offense,
294, 307, 506.
What are the offenses? Okay. Okay. 307 is there.
Yes, ma'am.
No, where is the injury
So
report?
wife and husband, ma'am. No injury there.
You are the husband.
Yes, ma'am.
You have a license to attempt. kill your wife.
False.
That's what you want to say.
Matter is
Injury
already-
report, I am entitled to see the injury report. If you have attacked with, what is the weapon used?
No weapon.
Okay, put it next week.
Not 2 weeks.
First week, second week. You are bringing joint affidavit and everything.
Yes.
They have settled their dispute.
Yes.
They
Last occasion you also not.
they separated or they
And they are staying together.
staying together.
Together.
Then to
Last occasion they are directed to fight joint
Yes,
affidavit.
yes, that's why I'm paying 2 weeks time maybe given because opposite part number 2 is ill, madam. That's why she is not able to come before this one.
she must be interested, want to test her husband for few weeks.
My lord.
She'll stay and see whether he
are
is
resigning-
behaving properly or not. Then
My
after
lord.
take a call.
They are residing under one roof, madam.
He must be tasting you. Anyway. Huh? Second, no. Taपर I 2 weeks marksand pehle
16th,
13th, 14th.
16th February.
16th.
Yes.
Okay. Yes. Next.
22.
Wait, please, your lordship. My lords, the petitioner has approached this honorable court for quashing of the cognizance order dated 8/5/2018, that Paddy case. There
My
is
lord,
no
in
criminal
this case, my lord, I want some time, my lord, because my lord, my
Yes.
friend take instruction from the IO. He is out of station for one.
On the last occasion, they took time for the,
Yes,
there
yes,
is no
yes.
case under section 409 has
Only
been
that,
made out, my lord.
that is the only things that the state will get instruction.
Last date, what happened? Nothing is reflecting.
Whether he has paid the entire amount or not,
My
that is to be taken in instruction.
Oh, acha.
Minor.
That is
Minor.
which is
I would like
If
to
already
draw
paid,
the
man, there is no case, my lord.
Yes.
Yesterday, I would like to draw attention of your lordship, my lords. The entire amount, 1 crore 22 lakhs somewhat had been paid within 4 months. Thereafter, they filed the charge sheet under section 409.
Somewhere it is written that limitation for recovery is over or something of that sort. No.
No, my lord.
that-
Actually,
that-
it was directed by this honorable court to pay within 6 months. We paid the entire amount within 4 months. And thereafter, the charge sheet has been filed against us. And how they extorted money from us, my lord. May kindly see annexure.
Anyway, let him come with the instruction. We'll,
My lord.
first
That's
week,
better.
we can give a short date only.
Yes,
How much time we do?
But-
First week?
No, 12 days required because he will come by 24th.
There is any bereavement in the family. 12 days, why 12 days?
Because in investigation,
He
he is out of station for investigation.
So make it on 12th February.
Yes.
My lord.
12 days
11th.
exactly, yeah?
11th.
11th. On the Sunday you can come, no problem.
is.
Sunday you can come. Make it 12th or 9th? 9th.
9th. 9th.
22, 20, 25, 25. 50% also complete. 25, huh?
23.
23.
My lord, item 23 pass.
Pass out.
24.
Pass out.
25 already.
Huh?
25 already been done.
25 within. I'll just come within 5.
All right. 23, 24 dira pass over.
Particularly section 6, 17 and 75 of JJR is not applicable for the petitioner because
charge sheet is filed.
charge sheet is filed. Trial is going on. Trial भी पोस्को कोर्ट रे चली other co-accused against other co-accused person, the son and the wife of the present petitioner. तांकर सुपरसेमेंट trial face करते. The fact of the case is like this. Earlier, prior to lodging of the present FIR, the wife of the petitioner had lodged the FIR for rescuing the victim. Victim to rescue karikiri as the victim was betrayed by another one Satyaranjan Malik. Taku rescue karikiri and kept her in her house. Thereafter, the victim got the compensation amount. After receiving the compensation amount to the tune of 75,000, the present victim lodged the FIR against the.
But for the earlier incident also there was an FIR.
There was an FIR.
Okay.
There was an error in the year 2007.
That FIR is lodged against that Satyanarayan.
That Satyaranjan Malik.
Satyaranjan Malik. And trial is going on.
No, trial
how you got the how did the girl got the compensation then?
Victim compensation by the help of the wife of the petitioner. She applied DLS DLS 75,000 टंका compensation.
FIR है तो ना सेती पे.
FIR.
Then what happened to that FIR?
Now pending before the post.
That's what I'm saying. Trial is going on in so far as that case. You say POCSO court is pending.
Another, the present FIR trial charge.
That's different. The earlier FIR is still there. Investigation is on. Where she got the compensation.
Compensation.
And you rescue the. Who are you? Are you related with this victim?
No, my wife is a social worker.
You got that girl to your house.
I rescued that girl. The wife of the petitioner rescued that girl.
Rescued and kept in your house.
Kept in her help kariya pai. Je gute jio ta enti betray heichi sab kotha sunla.
What happened to her parents?
Her parents is staying at Balesur.
So why have you kept her in your house?
The mother is dead.
Oh, allegation must be that girl was kept in your house.
No,
your husband might have exploited it. That's the allegation.
The mother of the victim is mentally retarded.
Malad, they helped the victim lady
and
for
the
getting
husband of the lady might have exploited this lady girl. That's the case.
Exploit ହେଇନି से victim compensation पाई साला परे ता घर को पळेला से टंकाटा तार फिक्स तानारे फिक्स डिपॉजिट ହେଇକି रहछि पूरा 4 वर्ष पे victim compensation fixed.
What is allegation against you in this FIR question?
जे मु ताको persuade गली if that victim will not marry my son तापर मोर कहबार अर्थ से लॉ जला FIR the victim was not minor. She was at the age of 20. Even if at the time of recording the statement under section 164 of CRPC, she herself gave her declaration that she is aged about 20 years.
The incident has taken place that time she must be.
No, my lord.
No
incident was
no or right will no or yes will be tasted in the trial, not in 482 proceedings.
My lord,
maybe you are correct. Maybe whatever you are saying is
my lord,
correct.
I am correct. More the petitioner has no role. Role nine.
That is the process of trial. No role or any role. Not in a 482 proceeding.
Now, passing of FIR so far as the offense under section 6, 17 and 75.
Allegation.
My lord, in this case, my lord, what happened? The victim lodged in the FIR. ମୁଁ FIR खाली पदक पढ़ दଉଛି ମୁଁ କ୍ଷତିପୂରଣ ପାଇଥିଲି ଯାହାର
You are reading page 12.
12 my lord.
Yes.
FIR.
Yes.
ଉକ୍ତ କ୍ଷତିପୂରଣ ପାଇବା ପାଇଁ ମୋତେ
where from you are reading in which line?
4 line.
ଉକ୍ତ କ୍ଷତିପୂରଣ ପାଇବା ପାଇଁ.
ଉକ୍ତ କ୍ଷତିପୂରଣ ପାଇବା ପାଇଁ ମୋତେ ପ୍ରତିଲତା ମଲ୍ଲିକ ପ୍ରସନ୍ନ କୁମାର ମଲ୍ଲିକ ଆକ୍ୟୁଜ ଏଠାକୁ ଆଣି ସାହାଯ୍ୟ କରିଥିଲେ ଉକ୍ତ କ୍ଷତିପୂରଣ କିଛି ଟଙ୍କା ପାଇବାରେ ସେମାନେ ମୋତେ ବିଭିନ୍ନ ପ୍ରକାର ପ୍ରଲୋଭନ ଦେଖାଇ ମୋତେ ପ୍ରସନ୍ନ କୁମାର ମଲ୍ଲିକ ମୋର ଅନିଶା ସତ୍ତ୍ୱେ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଥିଲେ 376 And that happened, my lord. She filed the for quashing of FIR. In the meantime, my lord, charge sheet has already been submitted, cognizance has already been taken. FIR very clear. I am very my doubt.
The petitioner is.
তারপরে সে তারা sorry my lord, I am sorry to that সে তারা কোর্ট অর্ডার হচ্ছে সেটা সে ডিক্লেয়ার করছি যে স্টেটমেন্ট সে ଦେଇଛି সেলফ ডিক্লারেশন রে যে এই যে টঙ্কা পাইবার যেতে সে দেলা অর্ডার মানে
টঙ্কাটা ভুলি যান্তু টঙ্কা ইজ নট
না না টঙ্কা কথা মু কহু
এলিগেশন দেখন্তু আপন
মোর কথা টঙ্কা কହୁনি 25/3/19 রে ডিএলএস কু সে লেখিকি দেলা जो लक्ष्मीप्रिया पात्र विक्टिम लेखिकी देला सेतेबेले से लेखिला जे ता बयस होउची 20 वर्ष एवं से लेखिची जे कहिची जे ए घटना रो 2.5 वर्ष लॉज एफआईआर लॉज बारो सेटा काहे 2.5 वर्ष पूर्वरु ए घटनाटा घटिला ता अर्थ जेतेबेले से घटना घटिला सेतेबेले भी से थिला मेजर ताको 18 वर्ष होइतिला
all these things in 482
से तारो कथाला पोस्को justice
you come to the charge sheet page 23 and read it.
Same, Lordship. The present petition.
What is wrong in the cognizance order?
Cognizance order, Lordship, kindly peruse page number 53.
Yes. Yes.
As per the FIR, the incident took place on
read the
FIR.
No, read the cognizance order. Firstly, that on or about 26th day of
date bhul date padi
wrongfully
wrong date
in the informant one allegation.
Lordship,
said abuse
as per the content of the FIR,
obscene language. Thirdly, causing hurt informant hereby committed offense 323. Sexual harassment, committed sexual harassment. Yes. What is the allegation?
It is a counter case, and as per the content of the FIR, the informant stated that the incident took place on 22 February 2021.
Okay.
But wrongly, the learned JMFC Kujang taken cognizance on dated 26th day of February 2021.
Okay.
And another important thing is the FIR has been lodged under section 354A against me.
354?
354A. But as per the statute, 164 statement is mandatory provision to record it. 164.
Why? Where from you got it?
164 provision 5A. In a case punishable under section 354, section 354A, section 354B, section 354C, section 354D, subsection 1, 2, 376. That's
keep all very clear. Where are you reading?
164 CRPC statement 164 and page number alag boy
read it. 164 clause
376B.
Which clause you are reading? 164 clause
5A.
5A. Okay.
That's it.
In cases punishable under so and so in their proposal, the judicial magistrate shall record the
it is mandatory.
The person against whom such offences are committed in the manner prescribed in so as soon as the commission of offence is brought to the notice of the police, provided that if the person making the statement is temporarily or permanently mentally but further that if the person making the statement is temporarily permanently. Yes, Mr. Raghuda, he says that under 5A added provision, if you invoke 354 capital A, then 164 was mandatory, which you have not done.
Under this, taken first time, my lord, I have taken instruction from the case that will reveal, my lord, whether they have.
The learned counsel for the petitioner is challenging
May I
the
please,
order
Your Lordship?
dated.
Deposition slip of
1 minute. Challenging the order dated 14/3/2022 passed by JMFCP Kujongo. Whereby the court below has taken cognizance of offence under section so and so against the petitioner. Next paragraph. Learned counsel for the petitioner points out that the cognizance of the impugn order, perusal of the impugn order would indicate that there is a complete non-application of mine. Because on 26th February 2021, the offences, none of the offences was alleged to have been committed. Whereas the cognizance order indicates that all the offences has been committed on 26th February 2021. So apart from that, he submits that once the offence under section 354 capital A is invoked under the command of subclause 5 capital A of 164 CRPC, the police is duty bound to record the statement of the victim. In the present case, 164 statement of the victim has not been recorded. Full stop. Despite that, the trial court has taken cognizance. Issue notice, Mr. Ravi, waves notice. 2 weeks, 1 week, 2 weeks.
2 weeks, madam.
2 weeks. February, would they give February 15, 16 or 16? 16. 16.
29. Thirty.
Adjournment.
31.
Your Lordship, the matter may be taken up on Friday. The conducting counsel is out of station.
You want an adjournment?
So the matter may be taken up on Friday.
No, you will not tell the dates. We will tell the date. But your request is allowed. Okay? Request is allowed. You will get a date. Okay?
32.
Withdraw. You have memo and all?
33.
My lord, I pray for adjournment.
Okay, adjourn.
Sorry, Passover. Sorry.
If he's seeking for Passover, after lunch, we have some matter. Let it come next week, 22nd, or any date, your lordship.
What is this?
There are some defect also there. Let him.
No, definitely ignored by this court.
22nd or 24th, or any date, your lordship.
Oh. Let it come on the
Second level.
Second February, ma'am. That's Sadha Vachi. 5
13, 14, 13, 15. Ochi.
13.
13th February.
13.
My lord, one more thing. I have filed a IA because my stand posted to 20th.
Then there is an indication that you will move application for trial court and trial court.
Yes.
You do that.
No. That is for last date only.
With the next date also, I am not saying anything. You can move. And he will cooperate.
The same order may be passed.
That's not required.
No, they are not bothering.
The
Because
problem is I want to follow a system, and you people seek adjournment.
No,
And when I adjourn it, I calculate it. If this matter, see today 50 matters are listed.
Oh.
I thought that some matter will be
I
taken
know,
up.
my lord.
Everybody is seeking adjournment. I am free after lunch. What will I do?
I am not seeking adjournment.
And memos are filed, 100
Only-
memos are filed.
Only I have.
And the people are waiting. And once you get an opportunity, argue it and finish it up.
No. My case, my lord, I have come with proper preparation.
So then let us
No.
hear it.
The major problem why I am seeking Pass over.
Okay, pass over. Let it be heard.
Pass over.
Some matters should be heard and disposed of. Otherwise,
What has happened wrong? Erroneously,
okay, it's all right.
judgment copy has been left in the office.
2
I have
o'clock you
sent
can
my
get.
associate to
2 o'clock you can get it.
Yes.
I'll get it. We'll hear. Next.
34. 35. 36.
Mr. Beardolai, kindly pay for an adjournment.
Adjourn.
37.
Copy not, sir.
What is this case? You not supplied the copy. Who is there? It is pass over means I will come. Second call. You can't come in between. Whatever. You come after lunch. Next 30. Pass over.
37. No, nobody appeared, but it's copy not, sir.
Let him come. He may give you a copy. 30.
Yes.
30.
38.
Why don't you argue unnecessary seeking adjournment? You can read and argue. I will accommodate you once you argue. If it is very heavy matter, then I will adjourn. Otherwise, you argue. You get an opportunity. Anyway. 38.
39. 40.
Item 45, please, Your Lordship.
40, yeah? Item 40?
Item 40, ma'am.
Yes.
My lord, in this case, the offences are under section 420, 408, 468, 471, and section 34 of IPC, my lord.
Yes.
In this case, the petitioner was working under the complainant initially. After that, I was willing and I got an offer to get next place in services, that is in the AMRI hospital, my lord. This is a Yatri Seva Private Limited, my lord.
You were working as what?
I was working as the in charge of that finance thing, important aspects of the company's, the complainant's company, Yatri Bhojan Private Limited, my lord. I gave a resignation letter to the company, a notice period that I've got another job at AMRI hospital, my lord, for which I would take the leave of the company, resignation from the company. Before that, illegally, I was detained by the police for 4 times to the police station without a formal complaint, for which they asked all of my documents of bank accounts and everything of that sort. On 30/11/2021, my lord, when I was supposed to leave my company, that was my last day. That was then the FIR was registered, my lord. It is in Annexure 2.
What is the allegation in the
The allegation they have made.
Who is the informant? Is your employer?
My employer, my lord. He is the owner of that Yatri company private limited, my lord.
What is the allegation?
He has given in a very formal letter pad, my lord, that
come to page 21. Page 24 rather.
My lord.
You read it.
On 30/11/2021 at 10:45 p.m., Director of Messi Yatri Bhojan Private Limited company reported that following employees who were involved with various misappropriation of company funds by using different illegal acts and methods for which the company has invited huge financial loss and unable to revive and to make payment the legal dues of different institutions and authorities. Smruti Ranjan Pareda, designation in charge operation. SK Saddam Hussain, designation unit head.
All of them.
All of them. They have written that.
Yes.
My lord, before I submit
Based
that.
on this preliminary inquiry,
My lord.
investigation,
My lord.
and industry standards, operating practices, they believe that the misappropriation would be approximately 15 to 20 lakhs.
My lord.
Read it. What is the allegation I have to see, na?
My lord. Further, he alleged that under direct supervision and a plan of Smruti Ranjan Pareda and other employees engaged in different institutions, dishonestly took money from different customers without giving company bill. Lately, it is evident that the above employees gave false bills to the customers to receive money from them. Hence, the case on this report, IIC registered PS case number 482.
Directed me to take up the investigation soon. Subsequently, I took up the investigation of this case, and during the investigation, I examined complainant so and so, spot with so and so, bank transaction detail, like accused Saddam, so and so, accused KYC, submitted during their joining time and production of the complaint. Director in the course of investigation, it came to the light that Yatri's, a unit of Yatri is running under the directorship and the complainant and partner in different part of the country, providing good services, so and so, hospitals, so and so, and different designation institutions, so and so, the company running the part of those, so and so, so and so, and the accused persons are posted since long influence, and he has engaged his you have employed your own relatives and all, huh? Further investigation disclosed that Saddam Hussein is an employee in Yatri company since so and so, posted unit there, and he was allotted a savings account so also we can be at 20,000 and looking at that's what the account statement yes.
That is the entire allegation, my lord, they have given. By the letter, it annexed to page 12, my lord. In that sentence, your lordship has, I mean, as per the IEO, they have stated that I have engaged all of those other employees, which they have alleged. In that annexed to page 12, my lord, they have nothing written, they have not even supplied any kind of annexes before the police in the form of a complaint. They have just said that an internal investigation, my lord. A sum rupees of 15 to 20 lakhs. Until date also, they have taken all my bank accounts.
You got all the charge sheet, entire charge sheet with you?
I do have, my lord.
You got all annexes and everything?
No, I don't have the annexes and everything. I just have the charge sheet, but they have written this complaint.
Whatever you are entitled, you will get it, no problem. What happened to this bail order?
Page 12, my lord, at the annexure 2, the complaint by the complainant, who is the employer, my employer, my lord, the petitioner's employer. He has given a formal complaint, my lord, that there has been misappropriation of 15 to 20 lakhs. There is no kind of materials to substantiate the same. The police also never been there. The 2,27,000 allegation, the police have taken statement from me before that date of FIR.
Do you think that in the 482 I should examine all this?
No, my lord. I'm not stating that. Especially in the charge sheet, entirely charge sheet, my lord, I'm stating that the section 4.
The test is on the basis of the allegation and the charge sheet allegation and all. Whether any case is made out accepting this allegation on its face value or not. That is the test.
My lord.
See, the allegations are wide allegations are made against you. So therefore, it is only the only option is to test this allegation in the trial
court. Especially for that only, your lordship. I will just cite one judgment of this.
You are on bail.
I'm on bail. Anticipatory, my lord. Anticipatory. The same thing, I will just citing a judgment, my lord, on this 4th of 2024 by the Honorable Supreme Court.
Which
paragraph 7, my lord.
Yes, read it.
Yes. Sorry, madam. Paragraph 5, madam. It is the precise contention of the appellant that even if the entire allegations are taken as correct.
That's what I'm saying. That's the principle. If you take it at its face value saying that it's correct, even then if no case is made out, then you interference of the court under 482.
That is why the 482. This judgment is
That's
for
what
that.
I'm saying. That exactly I'm The same thing I'm saying.
My lord.
You have to see the facts and the allegation in the FIR and the charge sheet,
My lord.
and accept that to be correct. The facts are correct. Thereafter, see whether any case is made out or not on the basis of those allegations.
My lord.
If no case is made out, 482 is available, I can quash it.
My lord.
If allegations are made, wrong, right, or not, I am not entitled under the 482 jurisdiction to go into it. I have to accept it to be true. See your allegations. Allegations are
420.
many allegations are there.
My lord.
I have taken it to be correct.
My lord.
If correct, then it has to be tested in the trial. Therefore, you go to trial.
My lord, in this order also, I have submitted on the order of the Honorable Apex Court. The allegations are also quite, I mean,
Oh,
too
allegations are
much.
different. Just see the allegations. I have just seen it now.
420 allegations, 420, 506 was also there.
Provisions are there, sir. Facts are different.
No, I'm not disputing that, your lordship, but in this 420 allegations.
Man, that
especially-
means all 420 of cases has to be quashed.
No, my lord. I'm not even saying that. Initial point of view, it has to be taken into a considerable amount, my lord. That the submissions they have taken, let my bank accounts be given to me. They have given after this final
I have
charge sheet.
checked your bank account to ascertain how much money you are getting and how much is found in your account.
They have found nothing,
And
my lord.
these are the corroborative evidences.
They have found nothing, my
The
lord. That's my
allegation to support their allegation, they see what kind of money you have in the account.
I do not have any kind
Those
of
are
money.
corroborative evidence. But
In-
the allegation remains is you were in charge of the organization, and the large scale misappropriation has been done. You have employed your own relative and your sister also in the organization, and through them you started exploiting the your position, and which led to the loss to the company.
That
And
was not even the complaint, my lord.
One Hussein, some Hussein was also there. He has got the salary of 2 lakh rupees in his account, 9 lakh rupees was found.
And he has
My lord, that was not even the complaint. That was the police finding, my lord.
Obviously, in the
Complaint-
FIR, everything will not be given.
He
These are
is
the
not
after
even,
investigation
he is
they
not
found.
even, he is not even my relative, my lord. Nobody is my relative, my lord.
But he is a co-accused.
No, no.
He was working under you.
That is a complaint by the complainant, my lord. That is the complaint by the complainant, my lord.
Well, you don't have a case. You tell me, shall I dismiss it or withdraw or what do you want?
Who have
Or
a case,
you-
your lordship? Adjourn it.
You have argued well
No, my lord.
and you tried your best. You tell me. I'll keep these points open for arguing at the appropriate stage. You get one more opportunity to come this court and again it will be dismissed. But I'll give that opportunity.
I seek for an
Land
adjournment.
counsel for the land counsel
Senior
for
to
the
appear.
petitioner seeks the present petition is filed under section 482 CRPC seeking quashing of the charge sheet, FIR and consequential charge sheet dated so and so for allegedly having committed offence under section so and so. Full stop. The petitioner seeks to withdraw this petition, keeping open all the points to be urged at the appropriate stage before the court below. The next part of the petition is dismissed, is withdrawn with the liberty as spread.
Much obliged.
Yes.
41.
May I please, your lordship?
Yes.
This matter involves a very limited question before the lordship.
Yes.
Before going to that, I will say that unfortunate case this one is that the executive is not carrying out the order, lawful order passed by the judicial authority. What happened? The petitioner's vehicle was seized on the allegation that it carried some foreign liquors. The petitioner was not arraigned as an accused. Thereafter, the petitioner approved before the law court below on section 457 CRPC for release of the vehicle. Accordingly, the court, after hearing the parties and calling for the report from the authority who seized the vehicle, passed the order directing the release of the vehicle And as per the direction, indemnity bond was filed, that was accepted, and release order was issued to the seizing officer to hand over the vehicle. Thereafter, they played the mischief. The seizing officer did not release the vehicle on the guise that it requires confiscation proceeding. And I have handed over the vehicle to the competent authority to draw confiscation proceeding. So this is the crux of the matter, that they are playing hide and seek, not drawing any confiscation proceeding, nor noticing me, and withholding the vehicle, violating the order of the court. When I read this point before the learned court below who passed the order, the court below expressed his inability that what I can do. And ultimately, I approached this honorable court with a prayer to direct the authority to implement the order of the court and release the vehicle.
Where is the impugn order?
Madam?
Impugn order is at Annex 3, huh?
Madam.
Let us see, read it. Which paragraph?
I have to. Last page to Ashilava. Page 35.
The release order was passed by the investigating officer.
Release order was passed by the court. And it was
And the factum of confiscation, already confiscated, that is not brought to the knowledge of the...
No notice was issued, nothing else. And after knowing that fact, the court passed the order to release the vehicle. That was the order.
Which is the releasing order? I think this is 24/7/2023.
Your Lordship may turn to order dated 4/9/23.
4/9/23, okay.
Ma'am.
4/9/23.
That was the order passed for releasing the vehicle.
Okay.
And the indemnity bond was filed and that was accepted. And the concluding...
No, what is this order? 25/8/23?
That is the order directing release of the vehicle. And thereafter it was said that the valuation and photograph of the vehicle is to be taken.
Yes,
it was kept in the seizing officer's custody.
It was taken.
And that was taken. All the documents were filed.
Thereafter this order was filed.
Yes, my lord. And the indemnity bond was filed and that was accepted and direction was given to hand over the vehicle by executing Jamana. Thereafter the mischief was played.
When was the confiscation order?
I do not know whether there is any confiscation order or not. No notice was issued. Hand in glove, the seizing officer and the excise department, they played the mischief in order to defeat the order of the court.
Date of the confiscation order.
Kindly turn to page 34.
25/8, the question is has been confiscated to the state by order dated 25/8/2023 by the authorized. 25/8/2023 is the confiscation order. That's what they say. 25/8/23. If 25/8/23 is the confiscation order, and the proceeding was going on, just see the order there at page, what do you call? I'll just just see. When the proceeding was going on before the JMFC court on 25, just see the order 25/8/2023. There is a detailed order under 457 order. Why it was not pointed out to that court that the confiscation has already been made?
That is the main crux. My lord, you'll also may kindly turn to page 34.
34.
No.
Okay.
Para third.
1 minute. 34.
34.
Okay.
Para third.
Yes, para 3. Okay. Impugn order you are ready.
Para third.
Peruse the report.
Peruse, no. You'll also may kindly start on 11/8/2023. From there.
Where is that?
After 5 lines. On 11/8/2023.
In the same paragraph?
Same paragraph.
Okay.
After 5 lines.
On 11.
On 11/8/2023, the petitioner files a fresh petition under section 457 of the CRPC, and this court called for another report from the IO regarding requirement of the alleged vehicle in investigation. On 16/8/2023, the report was received wherein the IO has mentioned that he has already prayed to the authorized officer cum superintendent of excise Cuttack for confiscation of the alleged seized vehicle. On the same day, this court called for a report from the authorized officer cum superintendent of excise Cuttack regarding present status of the confiscation proceeding. On 18/8/2023, the authorized officer cum superintendent of excise Cuttack submitted the report wherein he has mentioned that confiscation proceeding against the alleged seized vehicle has already been started, and a notice of appearance was sent to the owner of the vehicle for filing of show cause, but he has not appeared before him. Therefore, on 25/8/2023, this court allowed the petition of the petitioner and directed him for filing of photographs and video clips. And to my instruction, in the meantime, subject to correction by non senior, this case has been stayed. To my instruction, I will submit the.
This case has been
stayed, my lord, by the learned session judge. What I got the instruction.
But this order is stayed.
Yes. This is my instruction, but it's not. I am not sure, but I will get instruction of what happened to that after this order, whether it has been stayed or not. But to my instruction, I have talked to the officer, and he has stated that it has been stayed. But I will take perfect instruction.
I am surprised to learn one thing. How have you passed a confiscation order ex parte?
No, notice has been issued.
This is
Did
what
not appear.
See, read down the line.
Yes.
It says on 5/9/2023, authorized officer cum superintendent excise Cuttack submitted the extract of an order dated 25/8/2023 passed by him, wherein he has passed an ex parte order of confiscation.
That is why, my lord, the above line is the explanation.
And at the same time, the proceeding on 440/57 was going on before the JMFC court.
That was not within the knowledge of the conspiracy authority.
You are the prosecutors.
My lord.
You have to. This is under you. You should have informed the JMFC.
No, court has directed to file your written report. What about the confiscation proceeding?
And that was taken into consideration. That was taken into consideration. Thereafter, the JMFC has passed a detailed order on 25/8/2023 for asking for valuation and everything. And by taking into consideration those things, subsequent order of 4/9/2023 was passed, releasing the vehicle.
Report call for karagala. Report call for karagala.
तापरे तो 4/9 order ହେଇଛି 4/9 order କୁ ଆପଣ challenge କରୁଛନ୍ତି କି?
हाँ ସେଇଟା challenge stay ହେଇଛି. ସେଇଟା ମୁଁ କହୁଛି ଯେ in the meantime that has been stayed to my instruction, but whether it has been actually
I'll
stayed
simply
or
issue notice, you give a date chart, how
Date
things
chart,
are.
Yes.
May I say one thing? This type of litigation by the authorities they entering into, and they are playing with the court, definitely they intend to overcome the order of the court. So they may appear and file affidavit. Whether I appeared in the confiscation proceeding, duly it was notice was.
And he will bring the record of confiscation. I am giving a direction.
Yes.
You place the record of confiscation.
Yes, sir.
The court's order are not to be taken so lightly by
No,
the
no, no.
authorities. It is not permissible.
And in the meantime, it has been stayed by the honorable court.
Let us see. We don't know that. I will not say anything.
Yes, I'll produce all this.
Because the present petition is filed seeking implementation of order dated 18/9/2023 passed by JMC so and so in criminal code so and so. Take it over to page 4, take it over, whereby despite the so and so, Mr. Mahapatra, Ladies Senior Counsel, appealing for the petition, submits that despite a specific direction by the court below, releasing the vehicle under 457 CRPC, conspicuously, the order was subverted by refusing to release the vehicle. Mr. Maharaj, next appearing for the state, submits that there is a confiscation. The vehicle has suffered a confiscation proceeding. That perhaps the reason for which the vehicle could not be released. He also states that he has got an oral instruction that the order of release of the vehicle by the court below has been stayed by the superior court. Issue notice to the state opposite party. Mr. Maharaj waives notice. On the next date of hearing, the opposite party directed to place on record the record of the confiscation for the perusal of this court.
Yes.
A
free copy maybe.
Huh?
A free copy.
Free copy.
In course of them.
Confiscation record on.
Yes.
से record टा पूरा आ जाओ जोना पर जो किधर
और date would देखिए date chart टा.
हाँ date chart.
कौन overlapping है इतना date because the same day confiscation proceeding सेपटे चलची. एपटे JMFC order pass करची. Valuation पाई ये order पाई. So how things have transpired, let us see.
Yes.
There may be some confusion.
That is the only.
Date fixed करिए.
Date fixed. Huh?
16th February.
16th February.
16th February.
What is this vehicle? This vehicle is a car. What is that? Vehicle is a car or truck? What is that?
Scorpio vehicle.
43.
A free copy in course of.
एग्जीक्यूटिव जानिचंती कोन केमती काम हो ये लोक विचार किना तांको कटी जाइथले से सब कथा मिटि जाइथला कोई पूरा ओपन कोर्ट रे कोदी तांको दी जाइथल सब कथा
Perhaps your client have not taken advice from you.
I can't give that sort of advice. I have faith on the court. That's it.
Our endeavor would be, if there is a judicial order, it has to be complied. No executive authority has any right to subvert the orders like this. Then I would be taking very seriously for that try to sabotage the order of the court.
That
Let us
is
see
the confiscation of
and Mr. Maharaj is also of the same view.
Exactly.
We can't.
We can't. Nobody
can.
Before patting.
In that light, please.
Yes.
Assist so that we'll see.
Yes.
Find out.
Yes.
Before parting, may I say one thing before my lord? That is not a connection with any case. Whenever any young advocate they are appearing before my lord, I heard that your lordship is encouraging them. Give them time to prepare themselves. If there is any difficulty with the assurance that I will give you a chance. So they will be encouraged.
And I am surprised that the young lawyers are seeking time instead of arguing. They are scared that
rightly your lordship advised the other man, young man, that
you should argue if I am not able to give relief, I let them it. That's a better idea of doing it. Yes.
43.
My lord, notice could not be issued due to late file, my lord.
No requisites file.
Requisite file, but it's quite late, my lord.
42
Again,
42
No, wide order dated 15/12/2023. Notice was issued to the opposite parties. However, the petitioner has not filed requisites in time. Therefore, the notice to the opposite parties, opposite party or parties?
Opposite party, my lord.
Opposite parties, na party, kitne?
Party, my lord. One.
Opposite party is insufficient. Opposite party number 2 is insufficient. Let the petitioner take appropriate steps to serve opposite party number 2, adjourn to.
It was already filed, my lord. Since
Whatever you do, you lost a hearing unnecessarily. Yeah, okay.
44.
May I please, your lordship?
Yes.
The petitioner, the dealer who deals with the sales of tractor, my lord, tractor.
Tractor?
Yes, my lord.
Yes.
The property. My lord, opposite party number 2, who purchased a tractor from the dealer after complying all the formalities, my lord. Now his allegation is, my lord, for which he lost the affair, saying that I have sold the tractor. He has no allegation so far selling of tractor is concerned. The allegation is the original documents which he is required to show me, and thereafter he had to return him back. He said the original documents in respect of the sale of the tractor has not been handed over to him. That is his allegations. But my lord, since this tractor he has purchased against a loan incurred from the local bank, State Bank of India, Syndicate Bank, my lord, these documents are to be sent to the concerned bank because the bank has to verify and the document has to be returned to the concerned owner, my lord, who has purchased the tractor. Now he is blaming me that I have not returned the original documents of his tractor for which he has lost the affair.
He is purchased from you.
Yes, my lord. For which, my lord, I have not returned his. I have come for quashing, my lord.
Where is the original?
Original is now in the lying in the bank, my lord, and that was seized by the police during investigations, my lord. If your lordship will
What is the offense? What is the offense?
420, 471 by 34 IPC.
Who is opposite party number 2? You have got the tractor. You got the original from the bank. What is their unnecessary prosecution? Who is there?
No, it's unnecessary.
Who is for opposite party?
It's
You are not implicated?
Yes, I have implicated him as opposite party number 2, my lord.
Somebody is appearing. Because it was heard earlier also many times.
Your lordship, I have implicated him as opposite party number 2, and notice probably was issued. Your lordship may kindly see the last order of your lordship's order sheet.
Proceeding state. Who was appearing opposite party? Opposite party never appeared. Service never appeared. Last time also. Just take it. The original document pertaining to the vehicle has been handed over to the bank and at the relevant time for disbursement of loan based on which the loan was sanctioned and part payments was also disbursed to the petitioner. It is further submitted that without the original documents, the bank would not have sanctioned disbursed the loan amount. And this court finds some portion of the argument from the bank concerned. Yes, Mr. Goda, have you taken the instruction from bank?
I have, sir. Just a minute.
See, last order is you are supposed to take instruction from the bank. The IIC was directed to seek instruction from the bank, whether the original documents are there or not.
With your lordship's kind permission, lordship may kindly see I have obtained the certified copy of the seizure list from them, my lord, from the prosecution, where your lordship will find that the original
Original is there.
Yes.
You have seized from where? Bank?
Yes, my lord.
Confirmation of the delivery of the
So if it is seized and with the investigating agency, he cannot claim, my lord, the documents I will return him.
For registration. Original, what is this? Original money received.
Yes. He said the original documents, my lord. Original documents are seized by the investigating agency during investigation. And if I have handed over.
देखिए आप देखिए এটা last order has not been complied.
Last order, my lord, I have received a letter.
I'll keep it on 19.
19, my lord, I have also.
नहीं आपण এটা नहीं जानतु.
My lord.
19th रखुची.
Check कर.
I will quash it.
My lord.
Because see, the only allegation is.
I'll take instruction.
The only allegation is the truck was sold by him to the complainant.
My lord.
And he says that truck was sold, but no original paper was given. So therefore, 420 and all. The original paper, in fact, was given in the bank on the basis of which he got the loan. And loan was disbursed to him. And the original you have seized pursuant to the FIR. And what is left? Why unnecessary trial for this?
One date,
and you know it will be he will be a good. And notice was issued long back on March 2023
to the OP, my lord.
And opposite party. No, he is not
for
coming.
that reason he has not happening.
Obviously, he got the truck, he got everything. Why should he come?
And one date may be given.
So this is the wastage of prosecution time.
My lord.
Unnecessary wastage of your time by putting him to trial.
19th, my lord.
May I pray my item number 1414? Sorry.
Yes.
No, sorry.
19th रे आपण proper note करंतो सेटा देखि दियंतु and get the instruction so that we will finish it up on that day. There is nothing in it. आपण copy दियंतु.
I'll verify.
Notice escape ही जाइछि notice रगड़ा करो.
आगे देखि देबी.
हां देखि दियंतु. The order was 10/8/2023. There is a specific direction that Land Council is directed to obtain instruction in this regard from the concerned bank through IIC of the concerned PS. Now he says that it is seized by you, original. If the originals are there, it's all right. We will leave it and finish that.
On 19th.
Yes.
Go to copy.
Yes, sir. You
Item number 14.
14. Yes.
That's the case, my lord, where the petitioner, the husband and the relations, father, they filed the application for passing of the FIR on the ground that the matter has been settled upon the informant and both the petitioners, their lawyers, and their advocate and their one is an advocate.
At exact 2 o'clock, I'll take, sir.
I will, no, my humble prayer.
14, huh?
Yes, there is some mistake in the petition.
No, 14. Let us see if their advocate records I may be knowing. I will not be interested to do it. They have settled their dispute. Have they settled their dispute? Yes, yes. But you have not implemented the informant.
Yes.
No. Just see. Page 3. Implement करना करिया पड़ियो.
This is your lordship, there is some mistake also in the petition. Your lordship, permit me to correct the petition.
No, better that you implement.
Yes.
Because 498 वगैरह nothing can be done without the informant. Who is the informant? Wife or someone else?
Wife is she is also a lawyer.
No, she is the informant. Let us see. Tumya Priyadarshini.
Matter has been settled in the civil court final. Consent decree of divorce has been.
So therefore, you implement and will
Yes, ma'am. Yes.
dispose it up.
Yes.
Learned Mr. Naik, learned senior counsel, submits that this petition is this dispute is arising out of a matrimonial discord.
Yes.
Matrimonial discord. The informant is wife of petitioner number.
Petition number 1.
Petition number 1. Full stop. They have settled their dispute. They have settled their dispute. The mutual divorce agreement.
Yes.
Settled their dispute, and the settlement terms has already been acted upon. Acted upon. The court below
1/4.
Have-
13/10/2023.
on 13/10/2023,
CP number 583 of 2023.
in CP number 520/2022, the which court?
In the court of the Judge Family Court.
Judge Family Court Bhubaneswar have also dissolved the marriage by mutual consent. Mutual consent. Therefore, he has sought the intervention of this court for quashing up the present petition. Quashing up the present criminal prosecution against his clients. Full stop. The informant in the case has not been implemented. Therefore, he seeks indulgence of this court to implement the informant. The petitioners are allowed to implement the informant as opposite party number 2. Opposite party number 2. Next verse. Issue notice to the newly added opposite party number 2, returnable within 1 week. Apan ko kebe date name.
But I am aware that there is a mistake in the petition. What is the
He also submits that he would be correcting certain typo
Yes.
in the typo in the petition. Okay. Let him do so and list the matter on. Apan kebe kori peribe se dekhon to se asi online. Let them appear online.
Yes. Yes.
Don't bring them. They are lawyers. Why should come?
Yes.
Online.
6th
6th February. 6th February.
Yes.
Lease the matter on 6th February. Meanwhile, the petitioner and opposite party number 2 may file a joint affidavit. On the next date of hearing, the parties should appear before this court on virtual mode. Okay. On 16th, 6th February is item number 1. Exact 10 o'clock, 10:30. So that there will be no confusion. Okay.
Further proceedings.
Further proceeding in so-and-so state.
45.
Item number 45, my lord. The matter has been settled in between the petitioner and opposite party number.
Offense
Offense under section 198.
Okay.
I'm for the informant, my lord. I've already.
Where are the joint affidavit? Have you filed?
Well, yes, your lord. You kindly have a glance. Flag A, my lord. I've already filed.
They are staying together or they
separate? Separate.
490. What you call the mutual divorce?
Mutual divorce already.
And the money is paid.
There is no claim.
No claim.
Yes, sir. We have no objection. I have for the informant.
Sangeeta Acharya. You are appearing for Sangeeta Acharya.
Yes, sir.
And when the divorce was granted?
2023.
Do you have their what you call Aadhaar card and everything? Please don't.
No. Petition number 1 is also present.
Right. But where is the informant?
I am for the on behalf of the
But
informant.
he is not a present, na? You have her Aadhaar card and all.
No.
Show me his vocal adnama. Show me his.
I already filed my record.
You have filed?
Yes, sir. Along with the affidavit.
Why your client is not appearing? Can she appear through VC at 2 o'clock? Where is he?
He's staying Cuttack.
Cuttack?
Yes, sir.
Other than what is the problem? He can come.
Tomorrow.
Not today only. You through VC later appear.
Yes, sir. Yes, sir.
Today only through VC at 3. Let us make it 2 o'clock exactly.
Yes, sir.
Huh? Or 2:30. You tell.
2:30.
2:30.
Yes, sir.
We will take it up at 2:30. We will finish it up today only.
Yes,
tell her to appear. If she can't come, if she is in Cuttack, she can come very well. If she can't come for any reason, through VC, let her appear.
Yes.
Okay. And get the get her Aadhaar card also, please. Okay. Okay. 2:30.
Yes, my
Six, my lord. There is a case where the Honorable Court has last time directed the state to examine and to apply the Honorable Court regarding what is the material against the petitioners for which the charge sheet has not been submitted since last 10 years. Case has been initiated in the year 2013. A preliminary charge sheet was submitted against 2-3 persons in the year 2013. Thereafter, after 2 years, again, its preliminary charge sheet was submitted against some persons, not against the prisoner. And thereafter, my case is pending since last 2013. 13. And so far, the status of the prisoner is concerned. But Dinesh Kumar Tiwari, who is
you are
in CLMC number 2676, my lord. He is a legal practitioner of the local bar. And what is the allegation? Allegation is, my lord, absolutely nothing. Nowhere a single name of the prisoner has also been ascribed, my lord. But
what is Govardhan Naik?
No, I am for 2%, my lord.
You are Govardhan Naik?
No, I am for, my lord,
I am appearing for the first petition that is good.
I am for CLMC number 2676. There is Dinesh Tiwari and another, my lord, one Vijay Sahis.
Who is for these petitions? Jammu Mani and Sanatan.
My lords, for Govardhan, I am appearing, my lords. That
My
is
lord.
the item number, the
In,
first.
in one petition, there are as many as 5
Yes, my lords.
petitions.
For yes, my lords. that
You are
is-
appearing
yeah.
for one.
Yes, my lords.
And what about the other 4?
No, no. In that petition, I am
You are
appearing.
appearing for
Yes,
all.
yes, my
That's
lords.
what you tell. And which one? The other one? How many petitions are there?
And in CLMC number 2676, I am for one person. And one CLMC number 898 of 2023, I am for another Koiki, my lord.
You are for Dinesh Kumar Tiwari.
Yes, Dinesh Tiwari, who is the advocate, local advocate, my lord. And one Vijay Sahis, that is CLMC number 898 of 2023.
Ah, yes. 898 and 2676. Yes, sir.
My lord, charge sheet already submitted, my lord, on 7/6/2023, my lord. 7/6/2023.
What are the offences?
And the cognizance are taken, my lord. 419 and 420, 120B, 468, 471 are PC, my lord. 419, 420, 120B, 468, 471 are
What
IPC.
are the allegations against this?
Allegation, my lord, the misappropriated the compensation amount, my lord, the accused persons, my lord, and most of the accused persons they absconded during course of trial, my lord.
MACT.
No, my lord, no, my lord.
Now, my lord. My lord, a project, a land acquisition was there for the purpose of, my lord, a wraith irrigation project. And there, my lord, it is alleged that during that compensation of the land house tree, some corruption was made. And this allegation has been come up by an individual, a person of the locality, and the investigation was taken up. It was found that some officers were liable, for which in the year 2013 itself, the then, my lord, official, the person who was managing all sorts of things, he was, my lord, charge sheeted. Thereafter, 2 years thereafter, again, this preliminary charge sheet, some persons were charge sheeted. Now, these persons were although named in the particular process, but not charge sheeted. So, in this process, we have some persons have also approached this on report that date to have disposed of this directly because no case, why report that date? So, by the process, the case is linger up. We filed the application that because of this, the pendence of the application, this case for years together has also harassed us, my lord. And this Honorable Court has directed the moment we filed, the charge sheet was submitted. Now, this Honorable Court has tried to know what is the material, because kindly appreciate, in the year 2013, there was some investigation, some person's statement was recorded.
What happened to whether the trial proceeded in those cases?
That is pending. That is pending, well, and the Honorable Court has directed the state to apply this Honorable Court that because of the fact that there was some investigation in the year 2013, and from 2013 to 2023,
There are 10 years, what have you done?
yes, and what is the material based on which you have now charged the persons, because in the year 2013 there was some statement recorded. Now, if some statement has come up, then we have
Any material has come?
No, you have no
I
case.
guess.
Now, a bar submission that the accused persons are there. They have not been, they have absconded.
What is the role of the lawyers? Whether they...
My lord, they fraudulently, my lord, created some documents, my lord.
Huh?
Created some documents, my lord, stating there and there,
Let us come to the
Yes,
FIR.
welcome you are saying. If my lord friend submit a single line, my lord, I will withdraw my case, my lord, reject my appeal against Dinesh Tiwari.
So,
Let it also found my name also.
So that single line, so that we will get rid of so many
It
materials.
will go by one,
Now
my
you will
lord.
say that I have not examined, I have to read. That will be submission. Come on, my lord. I'm sure. My friend will say, I have not examined, I will examine.
Govardhan, my lord, the first case, my lord. So far,
Dinesh Tiwari.
Dinesh that धरती Govardhan धरती
This will be
Govardhan धरती first है.
काम करंतु आपण एटा बहुत मैटर अछि
My lord,
आपण गुड चार्ट बनांतु कार अगेंस्ट कोन
कौन अच्छी कर देबी आ वो डेट दे दो ये
नहले एटा करियो
my lord My lord, all total, my lord.
You give me the chart when
My lord.
you tell me, but I will not adjourn for a longer time.
Time नहीं कर.
1 week, my lord.
I will not adjourn for longer time. You think over in the that week, 5 to 9. You take any day.
हाँ नहीं. तीन जीवन उजुन.
Sir, I am for
ठीक है रोजा.
30th, my lord, 30th.
Huh?
30th.
नहीं.
Very good.
5 में करे. 8 आसो 8 तारीख.
ଆପଣ ଗୋଟେ ପ୍ରିପେୟାର କରିବେ ଚାର୍ଟ
ଚାର୍ଟ କାହା ନାଁ କଣ ଆଲିସ
କାହା ନାଁରେ କଣ କି ଚାର୍ଜ ସିଟ୍ ରେ ଫରଗେଟ୍ ଆବାଉଟ୍ ଏଫଆଇଆର ରେ କଣ ଅଛି ଚାର୍ଜ ସିଟ୍ ରେ କଣ ଏଫଆଇଆର ରେ କଣ ଅଛି ଚାର୍ଜ ସିଟ୍ ଗୁଡ୍ କଲମ ବରେ ଦ ଏଫଆଇଆର ଗୁଡ୍ କଲମ ବରେ ଚାର୍ଜ ସିଟ୍ if there is substantive allegation then we will proceed if there is no substantive allegation no corroborative evidence we will quash simple
on 8th my lord
ଆଉ ଏତେ ଏକ୍ସରସାଇଜ କରିବା ଦରକାର ପଡିବ
And one more thing.
And I am sure Mr. Ragada will concede to the fact that if there is no allegation, unnecessary somebody will not face the trial. If allegations are there,
they will face that.
They will face that.
One more thing I want to add. Let me, my friend also examine because in the year 2013 there was some materials and they have not charged it in the year 2013. Now in the year 2023 after 10 years. If there is some new material, then he has to place it before the court. Otherwise, with the same self material, when they have not charged it, what has prompted to charge the file charge it after 10 years?
Because you came to this court. If you would not have come to the court, it would have.
No, we have approached the court in the year 2014 also, my lord. In a series of anticipated bail applications. Because their contents were no material.
You are on bail, all of you.
So, some persons are on bail, some persons are not.
You avail bail immediately. You'll get it. Fact that it is the investigation is going on since last 10 years itself is a ground for anticipatory bail. Why are you not availing?
But if these things will come up, then we'll maybe scot free by the process. Yes.
Okay. Okay.
Entry order will continue in all the cases.
Entry order is already there.
No, it might not be said. It got to be continued.
Continue. Entry order to continue till next date avail.
All the cases. So it will be.
But no further adjournment.
No, but.
It's a peremptory order.
I'll call the IO, my lord, so that's it.
Call the IO, let him present in the court.
My lord.
We'll ask him.
But that order will pass. That last.
Why?
I will call.
This is which police station?
Nuapada.
Nuapada ଆସିବ ବେକାର ତାକୁ
Komana PS.
Nuapada ଅଛି da.
Online ରହିବା କୁହନ୍ତୁ.
Online.
Because unnecessary calling someone. Online ରହୁ ଦରକାର ପଡିଲେ ତାକୁ ପଚାରିବେ.
ମୁଁ ଡାକ ପାରିବି.
ଠିକ ଅଛି.
8 February.
8 ନା 8.
47.
47 ना.
Complainant and the petitioner both are doctors, so they filed an affidavit. Party number 2 has filed an affidavit for withdrawal.
Speak little louder. Or after lunch you will do.
No, my lord.
After having lunch only.
No, it's okay, man. I'll be louder. So opposite party.
Put the mic properly.
Opposite party number 2 has filed an filed an affidavit to withdraw the case.
You have settled the dispute.
We have settled the dispute.
What is the offense?
The offense under section 420.
Yes.
You're
yes. You're for opposite party.
I'm appealing for the opposite
yes.
party.
What is the, we can quash it.
Yes. Party also.
Party can.
Party is
present here.
The file.
This is there from? Cuttack. They feel insulted to come to court.
No, my lord. My lord directs, then
call it.
2:30.
We'll do it.
Fix up date, you lords.
Why? You can call online. Let them appear online.
Both are doctors.
Therefore, online.
They must have in duty. So your lordship will fix up a date so that on that day they will appear. Tomorrow day after.
Why are you presuming? You ask them. Otherwise, at 2:30 I'll adjourn. No problem.
Okay.
But ask them if you can appear in VC. We'll do it. If they are busy somewhere somehow, then we'll see. You just contact and get their Aadhaar card also.
My lord.
If they are there, nobody knows what happens tomorrow.
Correct.
So if they can come, it's all right. We'll do it. Finish.
Absolutely.
If not 2:30, let it be 2:45. Let it be 3.
So that it will be.
Ask them.
My lord. Oblige, man.
48.
the case diary may be required. Because I'm challenging the affair, which is a parallel proceeding going on to give a color of civil dispute. I mean, the civil dispute given a color of criminal texture. So on that score, because relying on several Supreme Court judgment, I have come up. Here is the petitioner who is a managing director of a company has acquired certain property way back in 2009. And after acquisition, he also got his name recorded. And some of the property, very few property he has sold. After 2009, Milord, here it was acquired. And in year 2022, the complainant claims that the property stands in his name. He had never executed any power of attorney with anybody, but somebody has impersonated him. Before filing this affair, another suit was also filed challenging all these soil deed and power of attorney. They are purely civil in nature. I have annexed this and he has suppressed.
If you have forced the power of attorney, then how it is civil?
Pardon?
If you have forced the power of attorney.
No, I am not forced. I am a beneficiary of that alleged forced.
See, the power of attorney was forced, and the on the strength of that power of attorney,
I purchased.
it is purchased.
Purchased by the company, not myself. The company. Company has purchased. And more of the two constitute an offence under 468 and 467. It must be proved that the author of the document is liable for the prosecution, not the person who is getting benefit out of that. That is settled position of law.
Yes.
And I have given a short note. You will also kindly, it might be there in the record.
Can we do it today?
My lord, ये गोटे document कौन दिया है जो document हम पकड़ नहीं.
Kuda?
A fresh prayer filed by the counsel for the petitioner is at page number 10, which is just part
Case number
C.
was different. I mean, the year was instead of 2022, it was typed at 12.
Kudan.
A prayer, the affair.
Who is appearing
Flag
for
C.
Yes, notice was issued to the informant. He has not appeared. He is contesting the suit.
नहीं notice टा confirm है ना.
Yes, yes. Last time it was there before another
tracking report. देखो तो कौन है?
It was checked.
Sufficient.
Yes. Checked and passed an order for final hearing.
Sufficient है.
The notice, when the notice was issued?
No, sir.
By order dated 3/10/2023, notice was issued to opposite party number 2. The tracking report indicates that the notice was received by the opposite party number 2. Thereafter, the matter was heard on 22/11/2023, 8/12/2023, and 19/12/2023. However, the opposite party number 2 has not appeared in this court. Mr. Mishra, learned counsel for the petitioner, submits that the opposite party number 2 equally pursuing his civil remedy in a declaratory suit, filed by him, being suit number.
And next submitted CS number 53 of 2022, page 35.
No, co-court rate.
Before.
Suit number, CS number 53 of 2022, which is pending in the court of civil
Religious
judge,
Senior Division, Chhatrapati.
Senior Division, Chhatrapati. Full stop. ଆପଣ କୋଉଠି ଫାଇଲ କରିଛନ୍ତି written submission?
That notice, when I got this information because some purchaser said that such a case is filed. Till date, I have not.
Is have you gone through?
No, I'll get the CD, my lord.
See, this matter is ready for hearing.
Yes.
You can hear it.
Yes, yes. You'll also fix up a date.
ଆପଣ ଯୋଉ ଦେଖିଲେ the judgment which he is relying upon.
नहीं, judgment तो कुछ दे ही ना.
There is a written note of submission.
Just check it up. If you
नहीं,
don't have,
no
I
written,
can supply another.
no written note of submission.
Mr. Mishra has also filed a written submission. Written,
You'll also make kindly direct to sir copy. Because I don't have any copies.
written submission, the copy of which is not available with Mr. Maharaj. Therefore, the matter is adjourned to a particular date, though, argue kari khatam kare. 1st February. 1st February?
Yes.
Get ready, we
Yes.
hear it.
A copy maybe some.
Yes,
right.
supply the copy. If you don't supply, it will be adjourned.
Yeah, definitely.
Better that you supply.
keep
He has,
everything in mind.
along with the judgment.
Personally, your
All
lordship
this
may,
judgment and written note.
personally may kindly be supplied.
Personally.
Office रे गला बेलको 40% मिस हे जो
49.
May I please, your lordship?
Pray for day after tomorrow due to personal difficulties. My scenario not attend.
You are asking for adjournment. The date will be decided by the court.
This is my Union of India.
This is my
Opposite party too.
This is Union of India, lordship. My lord, my charge is fixed for in this week, your lordship. If your lordship is then adjourning on the request, because last time also he didn't appear.
Which matter?
49, your lordship. This is a tax matter, your lordship. That
that matter. Tax.
My lord, yes, your lordship.
How many time?
So last time he didn't appear also. The lordship, therefore, lordship put it for today. And today morning also it was called.
I'll stay and put it in July. If this is the attitude. What is this? Write down. By way of this petition, the petitioner is seeking quashing of the proceeding. Proceeding pending before the additional chief judicial magistrate, chief judicial magistrate special court, Cuttack in 2(C), then CC case number 70 of 2013 under section
276B.
276B of Income Tax Act. Income Tax Act. Full sir. Mr. Divedi submits that the complaint is made against his client because he has filed the return belatedly. The full sir, the provision, the section so and so income tax indicates that if return is filed belatedly, the SSC is liable for interest. Yes. Full stop. He submits that he is ready and willing to pay interest to be awarded by the authority, authority, but the prosecution launched against him is uncalled for. Full stop. This next up. This is a technical offense being committed, being alleged to have been committed by the petitioner by filing the return belatedly, namely how many months?
My lord, as per their complaint, it is 12 months, your lordship.
Belatedly, about 12 months delay, about a year's delay, about a year's delay. Full stop. The matter was heard earlier, and the time was sought by the opposite party to seek instruction in this matter and argue the matter at length. However, in the last date of hearing, nobody appeared on behalf of the opposite parties, and today, Mr. So-and-so appears and seeks adjournment. The matter is adjourned to March 1st week. In the meantime, the proceeding before the court below so-and-so is stayed. Application to take up.
Deeply applied.
You enjoy the adjournment.
Let
him also enjoy. He's going to give the interest, take the interest and finish it up.
My lord.
That's what we said. Let it be interest at whatever rate you.
Rate is prescribed on the law also.
10% or something.
No, 1.5% per month.
Per month. Whatever statute provides.
201.
These are the technical offenses. It is a wastage of court's time. Better they impose penalty and finish it up. These are compoundable offenses also.
The tax is that 1.5% per month.
And in trial court, in en masse, these are compounded. I was appearing for income tax.
I know.
Just ACMM Malik. You remember in Tisari? I used to going with a lot of files and get it.
All I compounded, yes. Let's say only 1 year I can pay it also, if you will say. If your lordship, I can pay, if your lordship will direct also, I'll calculate and pay it.
No, 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 that I can't do.
My lord,
They will have
let it. Oblige, your lords.
Yes, Mulats.
Yes.
Mulats, here the order of cognizance is under challenge. The offense is under section 4 of the PMLA Act. Mulats, before going to the cognizance order, can I take you briefly to the FIR that is at page 13, Mulats?
Yes. Then you have a charge sheet now.
Mulats, yes, I'll come to the charge sheet in a moment, Mulats.
Yes.
Mulats, may see the first page, that is page number 13. The FIR was registered under section 420 and 34. I'm not going to the facts of this FIR right away. Then Malats may look at the chart sheet that is at page 18, Malats. Sure, Malats, 420 and 34, apart from these two, section
price cheat money and all.
Section 4 and 5 of the Price Cheat Money Act and section 4 of the Prevention of Money Laundering Act.
These are the predicating offenses.
These are the predicating. Now, Malats, I am not challenging cognizance under 420, 34 or any other offense apart from section 4 of the PMLA Act. Now, Malats, may kindly...
if these two offense goes, the added offense goes, then PMLA also goes.
Malats, I am at a different aspect. If Malats may just bear with me for a moment. Malats, there is a clear bar under section 45 of the PMLA Act for the police to investigate any offense under section under the PMLA Act. My lords, may kindly see section 45.
PMLA.
My lord, section 45, subsection 1, capital A. May I place it, my lord?
Capital
A. Capital 1A. Notwithstanding anything contained in the Code of Criminal Procedure 1973 or any provision of this Act, no police officer shall investigate into an offence under this Act unless specifically authorized by the central government. My lord knows all offences under PMLA are generally investigated by the Enforcement Directorate. That is the organizer. So here, my lords, police was completely barred from doing any investigation. They have done an investigation and filed charge sheet under section 4, my lords. Now, my lords, the next step is if, the order of cognizance, my lords. My lord knows that under PMLA Act, a special court is constituted under section 44. And it is that special court which can take cognizance of offences. Here, my lord, the cognizance has been taken by JMFC, my lords.
Who is appearing? Nobody. First time.
Plus, this is the third time.
Who is appearing?
Plus the state. Because since
yes.
My lord.
Yes.
So for the
PMLA has to go.
No. Why I am saying so? Because, my lord, it's a case, there is a decision of the Honorable Supreme Court where the, with regards to the Cosmetic Act, only the inspector of custom can investigate in the matter. That is the provision, the special provision.
Right.
But in view of the Supreme Court decision which is prevailing nowadays, let's say very important decision, which I have cited before Honorable Court Note bench, that if the offense alleged exclusively by the special act, then only the inspector is empowered to investigate.
What about cognizance?
If the penal code is there, well, the penal offenses are there.
Is 420 and 34.
Yes, if the penal offenses is there, the general police have every power to investigate. That decision I will file.
You can file the charge sheet under PML.
Yes, yes, yes.
And what about the cognizance? 44 bars.
44?
44 of the Act bars that cognizance has to be taken by the special court, designated court under
special court.
PMLA. But here JMFC has taken the cognizance of PMLA.
Because only because of the general provision.
How can it? It can be placed before special court. Once you invoke PMLA, it has to go to that PMLA court.
May I briefly submit, may I have a perusal of this order sheet? This record was sent to the PMLA court.
You justified, you have rightly justified by saying that judgment and all. Okay, I'll go with. But how a PMLA, how the procedural court JMFC court can take cognizance of a PMLA offence. What is this you are showing?
Malak, this record was sent to the special court under PMLA. The accused were also presented before that court. The PMLA court returned the file saying
My
that
lord.
since ED has not investigated
Why-
and there is no complaint by the ED, the special court cannot act upon it.
Why the case has not been put up before the special court? That is the instruction I have received. As there is no specific special court in the Subarnapur district. It's a case belongs to Subarnapur
No,
district.
that's wrong. It was placed before the special court. Special court says that since ED is not investigated, I will not take cognizance. Go to the normal court. That's what it says. Your instruction is wrong.
And
one copy may be
the
given.
the special court at Bhubaneswar is the special court for the entire state of Odisha.
I know that.
That is not a district.
But it was placed before the special court. Special court says that since ED has not investigated, how will you place it before me? Go to the normal court. It went to normal court take the cognizance. He is challenging that cognizance. Now the question is whether JMFC can take cognizance of a special statute, offense under special statute.
Yes, yes.
Where it says only the PMLA court can do.
ये जो कॉपीटा देले से कॉपीटा देले
ଆପଣ ଦିଅନ୍ତୁ ଗୋଟେ copy
ମତେ ଗୋଟେ copy ଦିଅନ୍ତୁ।
ଆକୁ
ମୁଁ ଟିକେ ଦେଖୁଛି।
all the judgment and everything you come. This
Yes.
is a case I have to pass PMLA. If
ମତେ
you
ଗୋଟେ-
can't satisfy, then I'll pass that part.
ଗୋଟେ କପିଟା ଦେବେ ଆଉ ତାର ଡିସିସନ ଯୋଉଟା ଦଉଛନ୍ତି ଆପଣ ସେଟା
Decision କିଛି ରିଲାଇ
ହଁ ଠିକ ଅଛି
Statutory provision rely କରୁଛନ୍ତି 44 and 45. ଆପଣ ଏଇଟା କରନ୍ତୁ, otherwise we have to pass the cognizance
ହବ
order
automatic.
so far as PMLA is concerned.
yes ସେଟା କଟିଯିବ ଆଉ କଣ
ତାପରେ ଯାହା ହବ, if you can justify the order of JMFC, then
Right,
it's all right.
right.
On the strength of the provision and whatever judgment you.
My lord.
Okay.
Malaj, my interim order may be continued.
Interim order to continue.
Any date you lordship fix?
Date short date first week, first week, second week. 7th February, because you will
7th.
heard it and we'll finish it.
Item, item 24 that has been passed over. Can we adjourn?
Passovers are at 2 o'clock anyway. He wants adjournment. What is the facts of the case?
On the ground of a compromise.
What is the facts of this case?
The offenses are on the.
Oh, 2 o'clock, exact 2 o'clock you come. Read the facts and come. Okay, then I'll adjourn. Okay, no adjournment. Let him come prepared. Lunchtime you prepare and come.
Ready ରଖିବ ଏ ଫାଇଲ ରଖିବ ପରେ
Bail deବେନି ତଳ court.
This is not bail court. I know that. I know
surrender.
that you have to surrender. I am not going to give you bail in 482.
Surrender illegal.
Then it is at the 439 court, not the 482 court. And you have to
See-
surrender again. That's what I said that
Bail
you
can
take-
deବେନି,
seek
sir.
appropriate remedy.
ସେ ଦେବେନି bail.
That's a different story altogether. Call the matter.
Item 10.
Yes.
Commissioner hearing, challenging order taking cognizance. Yes, you will find page 42 minutes. So for 307 is concerned, that is not.
42, huh?
Yes.
Yes.
Page 40. We include the order.
Yes. 307 you are
Yes.
against.
Yes.
What is the injury?
Injury, my lords, there are two events in one FI.
Where is the medical?
Yes, lords, you'll also find page 13.
13, 13.
30.
30. Okay.
This is the medical examination of Bishwambar Sahu, the injured. The cut injury, simple in nature.
30. Yes. 30. Simple.
And
what is the weapon of offense?
Seizure. A seizure.
Seizure.
Going to.
Where have you attacked?
Ear. In front of left ear. That is it.
Left ear.
Not a vital part of the body.
Parietal region also. Parietal region of the head. That is there.
Cut injury.
Cut injury.
1 centimeter.
Plus the learned trial court while granting bail, specifically, of course, it is for the purpose of bail. But the learned trial court has observed that there is no prima facie case under section 307. That order also I have given.
It is only cognizance.
Malice.
Then you have to still argue cognizance is. How can you find fault with the cognizance order? Cognizance while taking cognizance.
Prima facie case is not made out.
It is made out. Cut injury they are there. And the veracity of the medical report that will be tested at appropriate stage. But the cognizance court will not go into the merits of every individual offense and see. See, at stage you know, I can
That's
understand.
right. That's right.
The learned counsel for the petitioner seeks to withdraw this petition to argue all these points at appropriate stage of the trial. The petition is dismissed as withdrawn with the liberty as read. Granting the liberty as read.
23.
Petitioner challenged the FIR for questioning for a way of a compromise.
What is the offense?
Offense, my lord, that is also only 363. Last date also both appear. As the informant assistant, I won't case. Petitioner, informant relationship sister and brother. Due to some landed problem, person be appear person. We have both advocates also present. Last date also she asked the so.
Where? Sabut asindi ki jane asti.
Ati jane asti.
Accused. Where is the informant?
Informant is not present. Father the informant.
Father.
Victim guy.
Jogobandhu Naik is the informant.
My God, Jogobandhu Naik.
And Pujarani Naik is the. What is the allegation?
Allegation, my lord, FIR करते जे कुआडे पळी जाईची ଆମେ खोजा खोजी करू मेजर जीरो मेजर अछि आ पाइ जति एता इन मिनटाइम से पर होगा କିଛି ନାହିଁ ଆଉ ଏଲି ମିନିଟାଇम ସେ ବାହା ହେଇଗଲେ ତାପରେ ଛୋଟ ପିଲା ବି ହେଲେ ଅନ୍ୟ ଲୋକ ଯିବି ବଦଲା ଦେଇଥିଲା ପ୍ରେଜେଣ୍ଟ ପିକ୍ଚର ମେଟ୍ରୋ ସେଟଲ୍ ଇନଫର୍ମେସନ
She has married to someone else.
ପିଲାକୁ ଧରିକି ଆସିଥିଲା
Was there any allegation that they had relationship?
allegation କରିଥିଲେ ଯେ ଇଏ କୁଆଡେ ସେ କୁଆଡେ ପଳେଇ ଯାଇଛି ମୁଁ ଖୋଜା ଖୋଜି କଲି ଭାବୁଥିଲି ବୋଧେ ମୋର ପୁତୁରା ସାଙ୍ଗରେ ପଳେଇ ଯାଇଛି ପୁତୁରା କୋଉଠି ଖାଲି
They are related.
ପୁତୁରା ଗୋଟେ ସେ ତମ
ଆଚ୍ଛା
ଟିକେ ଆଗରେ ହଉଛି affidavit ଯଦି ଦେଇଛନ୍ତି and the affidavit page 2 that I am the opposite one 3 in this case and swear this affidavit on behalf of the opposite one 2 ଦି ଜଣଙ୍କ କଥା wi କରି ଜଏଣ୍ଟ affidavit ଦେଇଥାନ୍ତେ କି ଫାଦର ଅଲଗା କରିଥାନ୍ତା ମଦର କରିଥାନ୍ତା
No joint apply.
ଦବା କଥା କିନ୍ତୁ ଏଇଟା ଯୋଉ ଦେଇଛନ୍ତି ସେଟା ଅଛି ସେ ଆସି
Three has given. On
3 given
ତୁ ହଉଛି ଫାଦର
2 is present. Informant. 3 is the victim.
ପଚାର ଦିଅ
3 is victim. କଣ କହୁଛନ୍ତି? ପାସ୍ କର ପଚାର
ଏଇଟା ଆସ
ଆସ
କେସ୍ କମ୍ପ୍ରୋମାଇଜ ହେଇଯାଇଛି କରିଦବ କରିଦବା କହୁଛନ୍ତି
କରିଦବ ଦେଖନ୍ତୁ
କଣ କମ୍ପ୍ରୋମାଇଜ ହେଇଛି ତମ ଭିତରେ
ହେଇଯାଇଛି ନା
ଝିଅ କୋଉଠି ଅଛି
ଝିଅ ପାସ୍
ସେ ଆଇଥିଲା ଏଠି ଉତ୍କମ ଆଇଥିଲା କୋର୍ଟକୁ ଆଇଥିଲା କେବେ ନା ନାଇଁ କୋର୍ଟକୁ ଆଇଥିଲା କେବେ ଆଫ୍ଟର ଡେଟ୍ ବେଳେବେଳେ କଣ କି ଝିଅ ବାହା ହେଇଗଲା ଠାରୁ ରହିଛି ସେ ପୁଣି କମ୍ପ୍ଲେନ କରିବନି ବେଳେବେଳେ ଝିଅ ପିଲା ନା ବାହା ହେଇଛି କୋଉଠି ସେ ପୁଣି କମ୍ପ୍ଲେନ ଏଫଆଇଆର କ୍ୱେଶ୍ଚିଂ
ଚାର୍ଜସିଟ୍ ତ ଫାଇଲ୍ ହେଇଯାଇଛି ନା
ନା ଖାଲି ଚାର୍ଜସିଟ୍ ଖାଲି ଏଫଆଇଆର ଟା
The petitioner is seeking, petitioner is an accused. In the FIR, petitioner is the sole accused in the FIR, number so and so, under section so and so. Okay. He seeks indulgence of this court for passing of the same as he has settled the dispute with the informant and the victim. The allegation, the petitioner is the nephew of the informant. The allegation against the petitioner is that when opposite party number 2 was
the informant and father of the OP3.
I know the opposite party 2, when opposite party number 3 was missing, the opposite party number 2 gave this complaint, opposite party number 2 lost this FIR, inter alia alleging that he has doubt that his daughter has been kidnapped by his nephew, namely the present petitioner. Full stop. Then counsel for the parties now submit that opposite party number 3 has married to already petition number 3 has already married. So is that petition opposite party number 3 has already married to one Sarath Raut 2 years back. 2 years back. 2 years back. And 2 years back, and leading a happy marital life. Therefore, she doesn't want to proceed with the present case against the petitioner, who happens to be his cousin brother. The parties have filed affidavit before this court, and they are also present before this court. The parties have also filed their Aadhaar self-attested copies of their Aadhaar card, which has taken on record to substantiate, to establish their identity. Having taken into consideration the facts that Mr. Ragada appears for the opposite party number 1 state, and submits that the parties are related, and the victim girl has also settled in her life after marrying, after marriage. Therefore, it is a fit case.
And one line added the father of the victim present in the court.
Yes, therefore, there is no impediment in quashing this FIR. Taking into consideration the above-mentioned facts and circumstances of the case, the FIR number so and so under section so is quashed, and FIR and the consequential proceeding thereof are quashed. Petition allowed.
24.
And you take that on record. When I say take on record, means it should be there in record.
Aadhaar card.
Whose Aadhaar card? And what about the accused?
Accused ର ଦି ଜଣଙ୍କର ଦବ ନା
Parties means once I say the parties have filed, you are keeping one. I can't see that. Is there na?
ଅଛି
And in judicial record, if the order comes and it is not found, tomorrow if anything happens, you will be responsible.
exactly man sometimes they are
So
not
be
giving
careful about it. What is the order passed, whether these things are there or not. Point out it.
verify
Tomorrow anything happens, then it will be treated as if something is missing from the record. And the judge will not be responsible. It is only the attending staff. You will be in trouble. So be careful about it. Next.
24.
Yes, 24. Yes, tell me the facts.
Initially, the present petitioners,
Loudly.
the present petitioners taken money to give admission in one college. Taken money to give admission in one college from the informant, but they gave admission in another college.
But admission they have
Admitted.
to what is the offense?
Offenses are under section 420, 417 and 34 of IP.
So what do you want in this?
Questioning on the ground of compromisers.
And where are the parties?
A date may be which.
No, you have filed a joint affidavit.
That's it. Annex 2, that's it. Page 50.
Anita Sahu.
Anita Sahu.
What are the offenses? 417
or 2034. Earlier they also filed my lord another CRLMC 1, 2, 3, 4, 23. Perhaps that is in the they have
what
this.
happened to that case?
That in that matter, order has been passed, seeking no coercive action will be taken till conclusion of trial.
That is disposal.
Disposal.
সেটা along with that ASU.
Dismiss ki what happened?
Disposal with the order that Honorable Justice S. Mishra, Sasikant Mishra ordered that no coercive action will be taken in it by till a conclusion of the trial.
Then phone questioning on.
That is
Set question based along.
Questioning.
They have also filed questioning affair.
This is
In a question you got full-fledged bail.
This is the application on the ground of compromise.
Release this matter along with
CRLMC 1, 2, 3, 4.
Along with the record of CRLMC
1, 2, 3, 4.
1, 2, 3. Okay.
2023. 23.
Adjourn. Second week. Second week. We'll give a date. Next.
I think 28, 29.
March. End of March.
26.
Why 29th or 26?
26 has skipped.
26 also.
26.
What is this here? How this matter came? 3483 of 23. Is it coming under serial number? Let's check it. If the matters are listed, the lawyers are not coming, what is the reason? Seriously. What is this? Infractuous to me? What are they asking? Okay. Cash security of
50,000 release
of vehicle. Okay. Oh, urgent March. Next.
33.
May this is the case where I have challenged the rejection of the discharge petition of the petitioner and his wife, who was a
added as a co-accused by the aid of 109. This arises out of a PC Act case. Now, cases like that, there was no case against the petitioner, and at the verge of her retirement, there was this is not in the record, there was a proposal or direction from the state government to complete a road of 18 meters where a new urban community health center was made, and it was to be inaugurated by the chief minister. And within 10 days, it is not possible in anybody's part, government official, to make tender or construct the road or complete the road. But at the date of the inauguration is fixed, the petitioner is basically executive civil. So he made arrangement of his own effort. He called one contractor. He arranged from another mine, chiefs mining, who supplied the chiefs. Another person supplied cement, and the road was completed within 7 days. And this community health center was inaugurated without any problem. After 6 months, the person who supplied the chiefs worth 50,000, his daughter marriage was fixed. In the meantime, sorry to interrupt. In the meantime, the bill of that road is totally paid to that contractor. So
totally paid.
Totally paid. So he telephoned and requested him. His daughter marriage is there. He has not taken any security from you, but I supplied the chiefs. Please pay him 50,000. And his daughter marriage.
You told it to the contractor.
No, to the contractor. He told. Taking advantage that he has received the payment of the bill, he intimated to the vigilance. But in the same time, the petitioner was also sensitive. He was having 30,000 cash in his house. He may pay, may not pay. In the dilemma, he brought 30,000 with him. So that at least he can pay 30,000, we arrange 20,000 later. But due to that intimation to vigilance,
raid was taking place.
Yeah, trap.
And 30,000 rupees was recovered.
So it is a thing which happened without anybody's intention, only out of so what the BMC, Bhubaneswar Municipal Corporation did, he stopped giving any work to this contractor. Because due to him, an honest person was punished. Because he was arrested and was in 45 days in custody. So later, he got the bail and trial was started. But during the initial stage of the trial, this contractor appeared and gave his 164 statement that, in fact, I have taken 50,000 rupees of chips and 30,000 rupees of cement from different person at the risk of this petitioner. And I was supposed to pay, but instead of paying, I have filed the FIR. As so, the case was dropped and petitioner became acquitted. But arising out of that, this chapter was closed. He became acquitted. Arising out of that, a DA case was made up.
This is DA case? Yes. In the DA case,
In the DA case,
What is the check period?
The check period is or enter service period 1/8/1919 to 23rd September 2011.
So the story which you have narrated, according to you, came out to be true, and so therefore you got acquitted.
In the
That's what you are saying.
In the criminal
trap
court,
case, you have, but this DA case, you have to render your account. That's all.
yes. Now I am coming to the main point. In this case, the petitioner, that is the executive engineer, filed a discharge petition on 20th January.
What is the check period?
चेक पीरियड 1/8/1990 ରୁ 23/9/2021 1992
1/8/19
23rd
23/9/2021
23/9/90
2011
2011. So it is about how many years?
13 years 13 years 13 years 13 plus.
What is the asset disproportionate?
Disproportionate asset was found during investigation, that is 35,46,797.
No, I am.
How? Why discharge?
That time. The petitioner, the asset earned by the wife of the petitioner.
What is she doing?
She was doing PDS supply in 2 beds. One is Balipuda and second is.
So those are the issue to be decided in trial. Whether it
No. There are income flow from there.
That's right. You show it to the trial court.
Yes, I have shown.
But in this charge stage, how can that be taken into consideration?
In the charges also they have taken that.
Okay, but to see whether your wife was working, your wife was not working, all these things have to be pasted in trial.
No, that are on record. I am not going out of record. Lordship will find.
Come to the, this is the only charge stage. Come to the order of charge at MP order, Annexure 5.
Impugn order.
Annexure 5.
Impugn order is at page 111.
Read it out. What is the legality?
Before going to that, I am submitting a single line. This petitioner filed the discharge petition on 20th January 2023. Objection was filed by the PP on 25th February 2023 and the matter was heard on 6th March 2023.
Order was passed on 5/8/2023.
I have relied on as good as 6 judgments in trial court. But none of the judgments or my submission has been recorded in the judgment. And second thing is that if somebody hears the matter in March, first week of March, and passes the order on 5th of August.
Oh, that is Anil Rai.
Well,
Anil Rai judgment. It has to be reheard.
No. For the length of the period, is it possible?
That's what I'm saying. Anil Rai judgment, Anil Rai.
Yeah, Anil Rai. Because the second co-accused, she filed her discharge petition on 25th April 20.
What happened to that?
Pardon?
The other accused. Other accused has also filed?
Yes.
What happened to that?
That I am coming. She filed on 25th April. PP filed the objection on 15th July.
That is a weak point. You tell me what happened substantially.
A common order was passed on
And
page 111.
it was, here they've taken all the You tell me how this order is illegal.
How the order is illegal?
Which part you read it?
My lord, the basic principle says the IO should be fair, natural, and reasonable.
You while cross-examination, you
No.
ask this.
I'm coming. Why? Because before joining the state government service, this petitioner was working in telecom department from first senior project manager OBCC from 1988 to 4/8/89. That is at page 14 of my petition.
Yes, proceed.
Next page, ma'am. Thereafter, he joined in telecom department from 21/7/90 to 31/7/90. Here, during this period also, he was bachelor, he married in 91. So here got the sufficient income, but that income has not been taken into account. But
all these things has to be argued in the
no, my lord.
You want a mini trial at this stage.
No.
At our stage only everything has to be considered. How can it be possible? Try to appreciate this scope of 482 at this stage.
No, scope of 482.
You are on bail.
Very wide, my lord.
Not so much wide that I can conduct a trial here. Merely saying very wide will not make very wide. The judgments have curtailed the jurisdiction. I have to be very carefully exercise this jurisdiction while dealing with the cases of this nature. And the onus is on them now to prove a source, known source of income or unknown source of income. They will discharge that onus at the trial.
Supreme Court has
and you get benefit of that.
Supreme Court has also held that the charge sheet filed by the IO should not be ambiguous. It should take all the material into account.
That gives you the benefit at the trial stage. When IO will put to cross-examination, you confront the IO and you get benefit.
My lord.
Test in 482 is very clear.
Again, the petition
from the very face up to the record, whether any case is made out or not.
My lord,
Whether income is known source or unknown source, this is the trial. You say that the source are known. They say that the source is unknown. That is to be tested in the trial. How can I in a 482 say that no, whatever you are saying is correct, so therefore the source is known?
Obviously.
Whether the source is known or unknown, that is the factum of trial. And you want me to believe whatever you are saying, that the source is known.
I am submitting basing on document.
Then I have to believe you and give a finding that your source were known source of income in a 482 petition. Is it the jurisdiction of 482 to give a finding at this stage, at the charge stage, that the income which they are saying that it is unknown source? I will say that it is a known source. How can I say that?
My lord, I am relying on.
Show me any judgment which says that no, in a 482 stage, the High Court can take into consideration everything and give a finding that the source is known source of income. Which paragraph?
Let's turn to the case of Anjali Panda 3.
Not even
Page number 10.
paginated.
Page number 10 of the judgment. This judgment was passed by our own, in our own.
Which para? Which para? Manupatra print.
It is para 7, but.
Is it Manupatra print?
No, no, it is the certified copy, original certified copy, Xerox. Because I was conducting the case, I have written this certified copy. Now,
Yes.
may come to page 10.
Page 10, which?
Just before para 8, Lordship will find in
yes.
4-5 lines, the investigation officer is required to act in a fair, impartial, and reasonable manner in conducting the investigation without any bias or prejudice. In view of all the efforts said, in my considered view, there is no such pleading material to suggest that the petitioner abetted her husband or made any conspiracy or instigated in alleged acquisition of disproportionate asset by her husband.
But this is the case of 109.
Yes. Why I am submitting, my lord? I want to only get the discharge to the lady only. Husband will face the trial, I don't bother. Now I am coming to first judgment.
The lady is facing only 109.
Only 109. He is having her own business, everything.
You, both of you are petitioner here.
Who accused by the act of 109?
But you don't want to press insofar as Sarveshwar Jana is concerned.
Sarveshwar Jana is a prime accused.
But you don't want to press this petition.
No, I am not there. I am for.
What I am trying to say.
Yes.
You are not willing to press. You want to highlight that the discharge order passed by the trial court is not sustainable under law insofar as Snigdha Naik is concerned, who is charged under 109 only. That's what you want to say?
Yes, ma'am.
So therefore, you examine the issue insofar as Snigdha Naik is concerned. That is your first ground. So therefore, insofar as this petition is concerned, as far as Siddheshwar Jana is concerned, you don't want to press.
No. I don't want to go against for the Siddheshwar Jana.
That's what.
Only the wife.
What was the allegation in this case?
Against the wife.
Against the wife. What was the allegation?
They have.
You show me any document. What was that Snigdha Naik was doing?
Yes, I am coming.
PDF supply some. What is
yes,
that?
161 statement. I am coming.
No, I'm not on 161. I will not go to. But show me any document. On the basis of if you are saying that I was engaged in some other business under 161, it will be tested. Right?
No, in the 161 statement, it is there.
You tell me any document, PDF, supply, anything she was doing.
Yes,
show me something on record.
That I have annexed.
Show me.
The petition.
Don't make me to read for 161.
Yes, ma'am.
You have all documents, you can very well get executed. Why?
Yes,
I will expedite the trial.
Let's say I turn to page 73 of my petition.
73.
73. 72, Lord. Start. This is file document of Orissa State Civil Supplies Corporation Limited, plot number C/2, Napoli, Bhubaneswar 12. This is addressed to the district manager, Orissa State Civil Supply Corporation, for the sub-finalization of account of Naik Agency.
You are running a Naik agency.
Yes. I was running the Naik agency.
You show me in your declaration under the what you call 54 declaration that you have disclosed to the department that your wife is engaged in something. Have you disclosed?
Yes, ma'am.
Show me. Your wife is running a agency, name is Naik Agency. Have you disclosed to the department?
Yes.
Show me.
In course of investigation.
No, no, not investigation. Have you disclosed this fact to the department?
Yes.
Where is that?
I'm coming there.
When you got the agency registered and when you gave the declaration. Requirement is within 1 year you have to do it. Your wife is engaged in a profitable business, then it is required under the law that you should disclose it to the department. If you have not disclosed, then it is
No. I'm having the statement disclosed. Declaration is there.
Where is it? Let him find it out. You tell me what is the.
But as
Sorry, my lord.
prior to
This was left that said.
It is placed on record.
Yes.
Ah.
Very much on the.
Find out. Let me hear him. Meanwhile, yes.
so far as Pratima Behra case is concerned, my learned senior is relying. That is against the petitioner. That is in respect of misappropriation on the official favor. This honorable court has passed the order, and honorable apex court has held that setting aside that order has held that during course of at this stage, exercising under power under section 482, the court has exceeded its jurisdiction and conducted a mini trial. And another Anjali Pandai's case is concerned that my lord senior is relying the judgment passed by this honorable court, which has been set aside by the honorable apex court, holding that it is a matter of trial.
No, Mr.
So far as 109 is wife is concerned.
Sorry. Have you gone through the judgment? Order of the Supreme Court?
Yes.
What the bottom portion is there?
I'm placing.
You should have given that order also. Read out.
No, that Supreme Court held that it is like a judgment of conviction for
acquittal,
and the petitioner is acquitted by the High Court.
Naturally. If I'll do the same thing, I'm doing the same.
No, this was the verdict of the Supreme Court.
That's right. Obviously, in 482, you can't go into every detail, every document. I am inquiring because I have time. Otherwise, I would have dismissed by now. In the 482 proceeding, how much you can go in?
And in recent judgment, that in Sundar Rasu's case, my lord has held that court should not conduct, in exercising 482, he should not discharge the duty of a chartered accountant. Calculating this income, that income, etc.
No, that is the apex court judgment of 2022.
And so far as the agent's commission is concerned, that has been taken care of in the charge sheet.
No, the important thing is if the wife is engaged.
That has not been communicated.
That has to be communicated.
That is as per service rule. That has not been communicated.
No.
Another aspect, even if still then, the income shown in the income tax return by the wife, that has been duly taken care of. Proper examination commission received from the as an agent of that supply.
That is what I asked. First question is whether if your wife is engaged in a business of profit, have you informed it to the department and when have you done it?
Yeah.
After the file, FIR was lodged, if you have informed the department, then you are gone.
No, that has not been informed at all.
Then
I'm reading it out.
Which one?
Statement of Srimati Siddha.
No, don't read
Statement,
161 statement. I don't know. I will not read 161 in 482. You show me the document where you have informed this fact to the department that my wife is engaged in a profitable business. You have to give a declaration under the law.
When IO has recorded my statement,
you may say that, but you have to show the document.
Yes.
That is your defense, of course.
Yes. So far document is concerned.
Where is that? Show me. You have given it to your competent authority saying that my wife is engaged in business running.
No. Wife has filed separate discharge.
You are not able to follow what I'm saying. If you are a government employee, the law demands that if your wife or any dependent is engaged in any business profitable business under the law, that is 54 declaration. 54 declaration, you have to give that declaration to department within 1 year of starting the.
Oh, that is property declaration statement.
Property declaration statement. If you have not given, then you are out. Then the defense is also not.
That is the known sources of
If
income.
you want me to write all these things, then you will be in trouble.
Yes.
In known sources
In
of
161 statement, you might have said that I have stated, but you are the co-accused. You have to give the document to show that yes, to the department also I have informed that my wife is engaged and running a business named Nike agencies and all. She has a separate income. That much you have to tell.
charge sheet, I am placing one line, my lord. The commission of the wife received as storage agent has been calculated on the basis of the letter received from the DM OCSS Civil Supply Repair Corporation. So that means genuinely that benefit has been given by the IO. So how is
I am going one step ahead.
my lord, that is also in known sources. While defining the known sources of income,
that will be treated as unknown
my lord,
source.
that will be treated as unknown source.
If you have not,
intimated, my lord, my lord, I'm deeply obliged, my lord.
So that is the danger you are inviting. So better you. When was the FIR?
FIR was drawn on.
FIR was FIR ହେଲା 17/4/2012
और चार्ज शीट
31/8/2016
16 आज जाए कौन करने हो
ସେମାନେ time ଗଡୁଛନ୍ତି filing petition after at the best of the petitioner it is lingering.
You better that
no, my
lord,
at no point of time
I'll expedite the trial and go and face it immediately.
Immediately, my lord, I cannot abide my lord's order because the petitioner number 1 is now working in Jharkhand.
Whatever, that is a different story.
No, after retirement, his pension has been stopped.
Everything will happen. Therefore, that is the reason I am expediting the trial. If you have a good defense, you will come out because it's the 2012 FIR. So that is the reason I am expediting. Otherwise, expedition also not required. And if you have a genuine defense, all this document, you will get acquitted. If you want me to write a judgment on 482, then it will prejudice you. I will have to record everything, whatever you say. If you want, I want a judgment reason. I'll write.
At least I can see my lord say.
That is after you.
Then I may be allowed to submit my notes of submission along with copy of the judgment.
You find the note of submission. He has the note of submission.
My lord.
Give it to me. I will write it.
By next week, my lord. By next week, my lord.
You have seen my lord in Supreme Court.
But I will not allow you to
no.
Have a complaint that I have rejected
No, I
it
am
past
not
after
there,
3
man.
months. I will do it with you.
I am not.
You have a serious complaint against the court bureau. I will not give that complaint to you. I will do that.
By Monday, my lord.
By Monday, you.
34. For 1 week time for remove of defect.
You take as much time you want. Yes. He'll give it.
35.
35.
Mm. 37.
What is that? Okay, what to do? Either you dismiss or adjourn. Once you dismiss, then another application will come. Wastage of time. Better you adjourn to March. That's best idea.
37 copy will not.
Copy they are not interested to do. So give it March end.
39.
Obligement.
And remember, and note down all these things. If they give memo and all, you don't entertain.
Some memo from my already.
Huh?
Some memo kept it aside.
Kept it aside. Once it is adjourned, then no memo. Let it come at its own course.
No,
Yes.
39, 10 days may given remove department.
10 days.
I'm not sure whether 10 days or not, but you get the time.
After
45.
Hearing the thing, personal problem, she is unable to appear before this court today, but she sent her Aadhaar card. May kindly take her, my lord, Friday or Monday.
What is it? She is a doctor, you told, no? No.
No, no,
What
no.
is- What is the problem? She is in Cuttack only.
No, no.
Cuttack, no, he is not from Cuttack.
Also,
Matrimonial dispute, huh?
Yes, Lord.
matrimonial.
They are
She sent me
separated.
her
They are
Aadhaar card.
separated, staying together.
No, separated. Mutual divorce already drawn.
Yes, Lord.
No permanent alimony.
No, for she does not want
Yes, Lord.
alimony. And she return all her dowry articles.
She is working.
She is working.
And she sent me her Aadhaar card. No. If you Lord see.
So let her come because she, if no alimony is paid, I don't know what she understands. Let her come.
One chance me given.
Take it up Friday.
Friday to have been
Monday.
5th.
5th of February.
Kagru hi period. Eight में मुझे कोई lunch पुरानी.
I'm also interested one Friday.
You are interested, I am interested, he is interested. Your client is not interested. What to do?
Personal difficulty.
And she is the informant. She is not taken any alimony. What is running her mind, we know, never know.
Yes.
She wanted to get rid of you, got mutual divorce. But she may be interested to continue this.
Continuous.
Who knows? So therefore, it's very dangerous thing to.
Yes, Lord.
Yes.
5th of February.
49.
Yes.
47. 47. 47.
Okay. As my lordship had directed, the petitioners and the complainants are before my lordship.
There.
There.
Where are- Okay. You were asking time. They came or not?
I wasn't asking my learned senior friend.
Somebody was asking time.
Must be.
We will finish it up now. What is the offense?
420, 418.
403.
Okay. What was the allegation?
Dispute of monetary dispute. Okay, over there they have settled those.
No, what
dispute.
was the allegation?
That
Just note down a little bit.
my lords, there's an allegation that there was during COVID time there was some money that has been pending from the petitioner to the complainant. Hence, one CC case was filed and FIR subsequently FIR was registered.
156.3.
My lords,
This is the FIR.
my lord.
Both of them are doctors.
Yes, my lord.
Both of them are doctors.
Petition number 1 is the doctor. Petition number 2 is the son of the doctor, and opposite party number 2 is the complainant doctor.
At the instance of opposite party number 2, an FIR being FIR number so and so under so and so was registered. Inter alia alleging against the petitioner that what is the allegation? You said
The opposite during COVID period, the opposite party 2 had to receive some kind of amount from the petitioner.
inter alia alleging
That is page number 12.
Inter alia alleging that what is this bill of amounting 36,000? 36 lakh. Alleging that without submitting bill amounting to this is the Rajkumar Santuka, na?
Santuka.
Huh?
Rajkumar Santuka.
And what is this order? Chittaranjan Das order. This is bail.
Bail.
This is bail.
Bail orders. Anticipatory bail granted to the petitioner 1.
Here these allegations are there. Huh?
Right.
Ye para 3, page 15. Para 3 allegation is there. Okay. Allegation write down. While granting bail, the court has noted the allegation.
Right.
Okay.
Yes.
The petitioners were enlarged on bail on 10/5/2023 by the coordinate bench while allowing ABAPL number 596 of 2023. Learned counsel for the petitioner submits that the parties have now entered into a settlement. Opposite party is also represented by so-and-so advocate. Okay. Both the parties, the accused persons and the informant are present in the court. They are being identified by their respective counsels. They have placed on record the self-attested copies of their
Aadhaar
card, which is taken on record. Mr. Maharaj, appearing for the state, submits that since the dispute arose due to some financial
transaction,
due to the misunderstanding of some financial transactions, and the parties have now settled the dispute, there is no impediment, legal impediment to quash this proceeding. Next, taking into consideration the attending facts of the present case in totality, I am of the considered view that the FIR number so and so and the consequential proceeding arising thereafter is deserves to be quashed. Next, accordingly, the petition is allowed. The FIR number so and so and the consequential proceedings are set aside.
Highly obliged, madam. Grateful, madam.
आपण ना गुड़ा दे दे आधार कॉपी गुड़ा को फोटोकॉपी करी सेल्फ अटेस्टेड कर दिए हाँ सेल्फ अटेस्टेड the photocopy attested sign and you also a counter sign so that there will be no problem.
Grateful.